Hello, and welcome to the 2013 Ohio High School Mock Trial State Championship Round Competition. I'm Caitlin Schultz with Ohio Government Telecommunications. The Ohio Center for Law-Related Education holds this statewide competition every year, and it culminates in this championship round that will begin in a few minutes. We are coming to you from the Ohio State House on Capitol Square in downtown Columbus. The room that we're in right now is the Finance Hearing Room, and it is currently a hearing room for Ohio Senate committees, but it served as the temporary Senate chambers during the State House restoration in the 1990s. This room itself was restored during that time, and special care was taken to match paint colors and other details to their original state. When the building was originally constructed, however, this room was the law library for the Supreme Court of Ohio, which makes it an appropriate setting for today's mock trial. In 1901, the Supreme Court heard cases here in the Senate building and the room directly above us. Today, the third branch of Ohio government has its own beautiful and historic building, the Thomas J. Moyer Ohio Judicial Center, just a block away from here on Front Street. Today, two teams of students from Orange High School in Pepper Pike, Ohio, and Indian Hill High School from Cincinnati will argue a case before a panel of judges. They've been preparing for this as a team since September, when the high school mock trial case was released at the Ohio Center for Law-Related Education's annual Law and Citizenship Conference. Each year, a group of volunteer attorneys create an original case about a current constitutional issue that is interesting for high school students. After the case is released, the mock trial teams work with an attorney or judge to prepare their case. In fact, each team prepares for both the prosecution and defense perspectives of the case, but will only argue one side today. Orange and Indian Hill High Schools have advanced through 3 different levels of competition to make it to the state championship. The winning team will advance to the national tournament, which will take place in Indianapolis, Indiana. Let's learn more about the specifics of the case that the students have been preparing for over the past few months. The 2012-2013 case is titled State of Ohio versus Dakota Allen. The case is related to the Fifth and 14th Amendments to the United States Constitution, which are commonly referred to as the right of due process. In this case, a building behind Phillips High School burns down during the night and a maintenance worker is killed. The fire appears to be the result of arson, but there is little evidence regarding the perpetrators. Dakota Allen is a sophomore at Phillips High School. The morning after the fire, local police pick up Dakota and friend Quinn Patel at their homes. The police then engage in a lengthy interrogation process that involves driving to the scene of the crime and the victim's home, as well as various interrogation techniques. Late in the day, Dakota makes a statement claiming responsibility for the fire and is subsequently charged with murder and arson. However, Dakota later recants the confession. Dakota is the defendant in this case and has alleged that the statements were improperly coerced by the police in violation of the Fifth and 14th Amendments. Dakota filed a motion to suppress. Dakota will argue the confession must be excluded. The state of Ohio is the prosecution in this case. The prosecution will argue that Dakota Allen's motion to suppress should be denied because no custodial interrogation took place and Dakota Allen's confession was voluntary and not coerced. Our two teams in the championship round today are Orange High School, Team Shanghai from Pepper Pike, and they are the defense arguing for Dakota Allen. Indian Hill High School, Team Red from Cincinnati, Ohio, will be the prosecution, arguing for the state of Ohio. And to help us guide through what we're going to be watching is Lisa Eshelman, the new Executive Director of OCLRE and a co-chair of the 2013 Ohio High School Mock Trial Case Committee. Thanks for being here, Lisa.
Oh, it's a wonderful, wonderful day.
So first, legal concepts are often difficult to understand, and I was hoping that you could explain to us first the difference between the defense and the prosecution in this case.
Certainly, in this case, Dakota Allen filed the motion to suppress as the defendant, but the prosecution, the state of Ohio, has the burden to show that the interrogation and the techniques used were constitutionally applied. And so it's their burden, but the motion was filed on behalf of Dakota Allen.
Thank you for explaining that. And next, the case information mentions 2 other concepts that I'd like you to explain. There's motion to suppress and custodial interrogation. What are those?
In the motion to suppress, Dakota Allen is asking the court to exclude the confession. So they're asking to suppress that evidence from being presented to the jury. The other concept in custodial interrogation, what Dakota Allen is saying, that the police engaged in a custodial interrogation, and therefore he had to have been given his Miranda rights first. And because he wasn't given his Miranda rights, it's a basis for excluding that evidence as well.
Thank you. And what is the due process clause, and how does that relate to this case?
In every U.S. citizen is guaranteed due process of law. That is the minimal standard of care by any state agency or person to ensure that their rights are guaranteed. In this case, it's to ensure that his liberty is not unconstitutionally taken, thereby requiring the Miranda rights.
Why is this clause found in two different amendments to the Constitution, and why are they different?
The 14th Amendment applies the Fifth Amendment constitutional right protections to the states. So that's the reason why the 14th Amendment is also engaged.
Okay, great. And what other legal issues and questions do you think will be argued in this case today?
Well, certainly the defense is going to focus on all of the interrogation techniques used by the officers, claiming that in essence Dakota Allen was unable to leave at any time, and therefore it became a custodial interrogation. The prosecution, the state of Ohio, is going to focus on the fact that of all of the facts in the case that show that Dakota would have been able to leave any time that he wanted, thereby was not a custodial interrogation.
Okay, and how did the case committee this year come up with the idea for this case?
Well, OCLRE is really blessed because we have a large committee of lawyers with various backgrounds and experiences, and they bring all that to the table, and we actually brainstorm, and we really look for cases that might be of interest to high school students. In this case, it's a 15-year-old sophomore in high school.
Great. And as the committee came up with this case, what was the process for writing it and designing the arguments?
Actually, the case committee starts soon after today's competition. They'll meet in early April, and they'll begin to look at issues that might be out there that are constitutional, might be of interest. They work all through the summer, writing everything from the witness statements to the briefs. That process is concluded in early August so that the case can be presented at our annual Law and Citizenship Conference.
Is it difficult for the committee to make the case fair for both sides?
The committee works very, very hard to ensure that it's fair on both sides. But in addition to the case committee, the draft also is reviewed by our competition committee, and it's also reviewed by OCLRE's board of directors. So you have a large number of people who are looking at it to ensure that it's fair and balanced for both sides.
As the students work with their advisors and the volunteer attorneys, what kinds of questions do they ask the committee about the case throughout the year?
Well, the students are learning from the very beginning basic trial practice. So the legal advisors are engaged to teach them how to do a direct examination and a cross-examination. Those legal advisors also help the students put together a theory of the case. How is it going to be presented, as well as teaching them the constitutional issues and the case law that's involved. They're a critical component to the team.
How will the students be scored today?
They're scored on the same scoring mechanism that we've done for each of the prior 3 rounds. It's a 10-point scale, and so they are judged everything from their knowledge of the case to their trial presence as well.
So what should we be looking for today to see if the students are exhibiting those qualities?
Well, we're very excited today because at this level of the competition, you're going to see students who are exceedingly well polished, and the judges will be looking for not only their knowledge of the case, but how do they integrate the facts of the case into what the law is. So they're going to look for that analysis, that critical analysis skills, as well as their skills to present themselves, in front of a group of very prestigious judges.
Is there anything else that you'd like to say?
Oh, this is just a wonderful day, and I told the students earlier today the most important thing is that they have fun.
Well, thank you very much, and we'll look forward to talking to you again. Yep, all right. Thank you, Lisa. And we'll talk to Lisa again during the judges' deliberation to get her take on the students' performance. And joining me now is Todd Birch of the Ohio Center for Law-Related Education, and he's coordinator for the mock trial program. Todd, thank you so much for joining us.
Thank you. It's great to be here. It's a very exciting day.
First of all, can you tell us a little bit about the competition and how it works?
Sure. Each team is composed of students who portray witnesses and attorneys on both sides of an original case. Teams had to advance through 3 levels of competition to get here today. We hosted 31 district and 12 regional sites. 26 teams advanced to our state championship, and the final 2 are here with us today.
That's great. And what are the main goals of the program?
As with all of OCLR's programs, the main goal of the mock trial program is education. We want to educate students about the role the legal system and the Constitution plays in their lives and in society, and we want to provide them with an authentic environment like they have here today to showcase what they've learned throughout participating in the program.
What are the different elements of the competition and what skills are the students developing?
A mock trial, one of the many great things about mock trial is all the skills that students can learn. They'll build critical thinking skills, public speaking skills, interpretation and teamwork skills. And they'll employ those skills while they're portraying the witnesses and attorneys in this competition here today.
And how does the typical team prepare for mock trial throughout the year?
You'll actually see a lot of variance in how mock trial teams prepare. A lot of teams will start preparing soon after our case is released in September. And another one of the great things about mock trial is the flexibility a team have in choosing how to practice. Some teams will, practice their parts over and over, do their openings, closings, that sort of thing. Other teams will get very creative with some games and exercises they can use to build some of those skills that we talked about. So there's a lot of variance among the different teachers and how they choose to prepare their own team. And all the different methods can be very successful. And that's one of the great things that we have about the program.
What is the time commitment for the volunteers and parents and, of course, the students?
Sure. In terms of volunteers, it can vary from as much as a few hours to come serve as a volunteer judge, and we had more than 1,000 volunteer judges across the state this year. To greater time commitments, legal advisors can be working with the team for months. All of our district regional tournaments are supervised by volunteer coordinators who also spend a good deal of time helping to put those competitions together for us. So it can really run pretty extensive to just a few hours.
And do you find that the same schools have strong teams every year?
Well, some schools are strong from year to year. Indian Hill High School is here with us today, the defending champions. They've been very successful the last couple of years. But another great thing is that we see new schools every year. For instance, Orange High School here today, it's their first appearance in the state final round. So they're a new up-and-coming team that we'll be seeing here today.
And why are there more than one judge?
Sure. The way each trial is scored, each judge will complete a ballot, and the team that wins, and based on points, the majority of the judges' ballots, will be declared the winner of a particular trial.
Okay, and how similar do you think this mock trial is to a real trial if you were to walk into a courtroom?
Well, of course, we strive for authenticity, and a lot of the things that you'll see today are very similar to what you'll see in a real courtroom. All the major trial elements in terms of opening statement, closing arguments, direct and cross-examination are going to be very similar to what you'd see in an actual courtroom. Of course, there'll be some differences. This case was written, as Lisa mentioned, to be balanced. You might not see that degree of balance in an actual court case. You also won't see a verdict in terms of the motion being granted or denied. The winning team will win based on total points for how effective the arguments that team makes were.
Thank you. And what will happen next for the winning team today?
The winning team here today will have the opportunity to advance to compete for the National High School Mock Trial Championship in Indianapolis, Indiana, and that'll be taking place in early May.
Okay, great. And where can we find out more information about that national championship?
Sure. Their official website is 2013nationalmocktrial.com.
Thank you very much for joining us, Todd.
Thank you.
And next, we are going to hear from Jared Reitz. He's the Director of Programs at the Ohio Center for Law-Related Education. So thanks for being here, Jared.
Oh, thank you for having us.
So first of all, can you tell us what OCLRE is? And we know it's more than just this mock trial here today.
Indeed. The center is celebrating its 30th year this year. It started 30 years ago as the Ohio Mock Trial Program and has now expanded not only programs about law, but civic education, social action. We have programs for teachers. We're a not-for-profit, and we're proud of the fact that every state has law-related education. We're one of the largest in the country in terms of the programs we provide.
How do you approach teaching students about the law?
Well, we align everything we do to the academic content standards, first of all, for English language arts and social studies. And with mock trials, for example, they work with legal advisors. So as Todd had said, everything we do is authentic as possible. We have a teacher conference where we have sessions for the legal advisors as well as the teachers, and we'll do amendment issues and so on that center around the case so they can then go back and teach students.
What else are the students learning through the process of this mock trial?
Well, as Todd had said, they're learning a lot of skills. They're learning to work collaboratively, but yet think independently. Think on their feet. They've got to listen. They've got to strategize. They have to be prepared to, as you know, in real life, answer some tough questions and also pose those tough questions.
Great. Is there anything else that you'd like us to know about OCLRE and the high school mock trial?
The mock trial program is the largest academic competition in the state of Ohio, and we're the second largest mock trial program in the nation, second only to California.
Great, thank you very much. You are watching the Ohio Channel as we broadcast live from the Ohio State House for the 2013 Ohio High School Mock Trial Championship Round. Orange High School and Indian Hill High School are going to be arguing the case entitled State of Ohio versus Dakota Allen. The case involves a high school student who was interrogated and charged with murder and arson. It looks like the proceedings will get underway, so we'll take you now to the main floor of the courtroom.
My name is Jerry McBride. I'm a judge of the Claremont County Court of Common Pleas. Can you hear me? My voice doesn't always carry the best. And I'm also a member of the State Competition Committee, and I'll be the presiding judge in this competition today. And I would like the scoring judges, if they would each introduce themselves also. Perhaps we'll start at the right side.
Good morning. I'm Robert Cupp, former Justice of the Supreme Court of Ohio.
My name is Tom Lammers. I'm a general practitioner in Salina, Ohio.
Gary Daniels, Associate Director for the American Civil Liberties Union of Ohio.
Pat Fisher, Judge on the First District Court of Appeals and President of the State Bar Association.
Shirley Cochran, a local mediator and attorney and a member of the State Competition Committee.
Lynn Slibby, presently Commissioner on the Public Utilities Commission, former legislature, former judge on the 9th District Court of Appeals.
This is the case, State of Ohio versus Dakota Allen. And before we begin, I started out this competition, I think, with about 375 teams. You are the final two teams. I think each one of us feel very honored to be able to participate as judges in this trial today. And I want to wish each team the best of success today. Are both sides ready to proceed?
Yes, Your Honor. Yes, Your Honor.
We'll start with the state, then go right ahead.
Before my time begins, I'd like to reintroduce my team and myself. My name is Gloria Park, and along with my co-counsel, Aaron Hall,
Your Honors,
we will be representing the prosecution or the state of Ohio in this case. Now, to do this, we'll be calling two witnesses to the stand in this order. First will be Detective Samantha O'Leary, played by Reagan Wilkins.
Good morning, Your Honors.
And second will be Dr. Casey Highlander, played by Catherine Fay.
Good morning, Your Honors.
May it please the court. On the morning of September 22nd, 2012, Detectives Sam O'Leary and Alex Jones were assigned to investigate an arson that had occurred the night before at a high school maintenance building, resulting in the unfortunate death of the custodian, Sheldon Brown. After being informed by anonymous tipsters of two potential suspects, Detective O'Leary and Alex Jones picked up Dakota Allen and her friend Quinn Patel to investigate the crime. Now, this was after they had received permission to do so from both the defendant's father and Ms. Patel's parents. The defendant and her friend were taken to various locations throughout this investigation, with a break in between to use the bathroom and to eat lunch. At these locations, the defendant and her friend were encouraged repeatedly to tell the truth, to tell Detective O'Leary and Alex Jones anything and everything they knew about the arson. These investigation techniques were utilized until the defendant confessed, stating, "I started it. I never meant to kill anyone." Upon being reunited with her father, the defendant confessed again. The defendant has now filed a motion to suppress the confessions made following the investigation. Now, Your Honors, there are two issues at hand today. First is whether a custodial interrogation occurred, and second is whether the confessions made by Dakota Allen were coerced or voluntary. Now, in order to determine whether a custodial interrogation has occurred, we must apply a two-pronged test promulgated by the U.S. Supreme Court in the case of Thompson v. Keohane. The first prong of this test concerns the circumstances surrounding the investigation that occurred on the morning of September 22nd, 2012. And the second prong of this test is whether any reasonable person in those given circumstances would have felt free to leave. Now, Your Honor, the defendant herself will testify that she has had previous experience with the police. And Dr. Casey Highlander, the defendant's high school counselor, will also testify that the defendant is smart, intelligent, and calculating. And this, in tandem with the fact that she has had previous experience, only goes to show she knew what to expect. Detective Sam O'Leary will testify that not only were Ms. Patel and the defendant given time to eat lunch and to use the bathroom, but they never requested to call their parents. And Your Honors, you won't hear from the defendant that she ever asked the detectives at any point in the investigation to take her home. Both the defendant and Detective O'Leary will testify today that the defendant had her cell phone with her throughout the entirety of the investigation. She could have used this phone whenever she needed to, whenever she wanted to call her father and ask to be taken home, but she didn't. Therefore, the prosecution will maintain that the detectives cannot be held responsible for knowing the unarticulated, subjective thoughts of the defendant. Now, in order to determine whether the confessions made by Dakota Allen were coerced or voluntary, the court must consider the totality of the circumstances test, which, like the first prong of the Keohane test, applies the circumstances of the investigation of Dakota Allen in order to determine whether her confessions were coerced or voluntary. Now, Your Honors, the defense might claim that Detective O'Leary got physical with the defendant, a claim that Detective O'Leary will refute herself in court today. You'll hear from two witnesses, including the defendant herself, that the defendant is dishonest. They will testify that the defendant lied to the officers during the investigation, that she misbehaves and then lies about taking her own medication, that she has a history of lying to avoid the negative consequences of her own actions. And what bigger consequence than coming to trial for arson and murder? The prosecution asks the court to keep this in mind throughout the duration of the testimony today. Therefore, we respectfully request that you rule in favor of the prosecution and deny this motion to suppress the confessions made by Dakota Allen. Thank you.
Thank you very much. Counsel for Dakota Allen, you may
Yes, Your Honor.
proceed.
Good morning, Your Honors. My name is Evan Wall, and today with my co-counsel, Shivangi Bhatia, we will be defending Dakota Allen. We will be calling two witnesses today, Dakota Allen, played by Hannah Levine.
Good morning, Your Honors.
And Alex Jones, played by Karen Bathna.
Good morning, Your Honors.
May it please the court. Just as the founding fathers believed that America could only be as strong as she was free from tyranny, an individual may only live an unencumbered life if their rights and liberties are properly protected. Our rights and liberties are the sacred pillars that bear the weight of this nation. They are our personal security blankets that cloak and protect us from injustice. However, when this cloak is lifted and our rights subverted, the pillars begin to fall as the foundation of our nation's freedom crumbles. In this case, the Fifth Amendment to the Constitution, which protects against compelled self-incrimination, and the Due Process Clause of the 14th Amendment, which ensures that statements are made voluntarily, are the pillars that we must fortify. Today, the prosecution bears a burden of proof as the defense motions to suppress the confession of Dakota Allen. We believe that per Miranda v. Arizona, the confession was illegally obtained as the defendant was interrogated for over 7 grueling hours without being properly Mirandized. We will demonstrate to the court that the two-pronged test established in JDB v. North Carolina should be the governing law to determine if a subject was in custody. The test first examines the circumstances surrounding an interrogation, and second, asks the court, given these circumstances, would a reasonable person, in this case, a reasonable 15-year-old girl, have felt that she was at liberty to terminate or leave the interrogation? The court should also follow the ruling of Haley v. Ohio, which determines specific factors, particularly age, to be essential in determining the voluntariness of a confession. Our first witness, 15-year-old defendant Dakota Allen, will describe the 7-hour interrogation in which she was subjected to taxing emotional, psychological, and physical abuse, deprived of her daily medication and other basic human needs. We will prove that Dakota was in fact in custody and therefore not at liberty to terminate or leave the interrogation, as she was denied her request to go home and rarely left alone. In addition, Dakota's declining physical and mental state, in combination with her age and badgering police interrogation, contributed to the involuntariness of her confession. Our second witness, former Detective Alex Jones, will corroborate the defendant's account of a day-long interrogation and provide insight into Detective O'Leary's emotionally tainted view of the case due to pre-existing personal relationships. Detective Jones will ultimately show that the defendant's will was overborne by the circumstances surrounding the interrogation, deeming it involuntary. Through these testimonies and through cross-examination, we will prove that it was imperative that Detective O'Leary read Dakota her Miranda rights prior to the interrogation, as she was in custody when she incriminated herself. In addition, because of the defendant's age, physical, and mental states, the police actions that affected her power of resistance were particularly notable and heinous. This sadistic usage of force, deceptions, and threats on a 15-year-old girl, no less, are all vital in proving that the defendant's rights, as guaranteed in the 14th Amendment, were violated. At the conclusion of this case, we will ask the court to grant the defendant's motion to suppress the unconstitutionally elicited confession and to deem it involuntary. Thank you.
At this time, I'll ask the bailiff to please swear in all the witnesses.
All witnesses and parties who are to give testimony in these proceedings, please step to the front. Please raise your right hand. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, and that your testimony will comply with the rules of the Ohio mock trial competition?
I do.
You may be seated.
Ms. Park, you may call your first witness.
Yes. At this time, the prosecution would like to call Detective Sam O'Leary to the stand. May I proceed?
You may.
Please state your name for the court.
Sam O'Leary.
And what is your current occupation?
For the last 20 years, I've been working in the police force. For the last 16 years, I've been a detective, and within the last 8 years, I've been assigned to the homicide unit.
And what sort of training have you received for your occupation?
I've received extensive training in crime scene investigation techniques with a specialized training in digital forensics and other forensics.
Now, have you received any training in the field of investigation?
Yes, ma'am. Just recently, I completed the advanced investigation techniques for law enforcement investigators through the Federal Department of Homeland Security.
Your Honors, at this time, the prosecution would like to qualify Detective Sam O'Leary as an expert in the fields of police procedure with a specialty in investigation based on her requisite experience, training, and education pursuant to Evidence Rule 702.
Counsel?
Yes, Your Honor, we have an objection. The defense believes it's improper to make Detective O'Leary an expert, as we are here to discuss the techniques used by Detective O'Leary in this case and to discuss if they were proper or not. Therefore, it's improper for her to be testify as an expert in her own techniques.
May I respond, Your Honor?
You may.
Regardless of whether Ms. Bhatia believes that this is an improper if this is improper for Detective O'Leary to be qualified as an expert, the prosecution has laid the proper foundation according to Evidence Rule 702 for her to be qualified as such.
The court finds that the threshold has been met for establishing the witness as an expert. You may proceed.
Now let's talk a little about your police work. Do you have a partner?
Currently, I do not, although for 5 years I worked with Detective Alex Jones. We worked this case together before his early retirement.
Now, could you tell the court a little about your investigation techniques?
I would definitely say I'm more of an old school kind of gal, and the fact that I find the empathetic and understanding approach is far less successful in obtaining useful information than a more direct approach, especially when you're working with street savvy suspects.
And why do you stick with this technique of yours?
Over the 20 years of my career, I've found hundreds of cases, and I've found that I've developed the mantra that if it works and it's by the book, I'll use that.
Now, let's talk a little about the morning of September 22nd, 2012. Could you tell the court a little about what happened on this morning in question?
Yes, ma'am. Jones and I were assigned a new case that morning by our sergeant, an arson at the local high school.
And how did you go about this investigation process for what you were just assigned?
Jones and I went to pick up the defendant, Dakota Allen, and her friend, a Miss Quinn Patel.
Did you pick up Miss Patel and the defendant in a police vehicle?
Not exactly. It was an unmarked vehicle. It didn't have the screen between the seats.
Were you wearing your full police uniforms?
No, ma'am. We were not in dress blues.
Now, what did you know about the defendant and Miss Patel prior to this investigation?
We were familiar with them, as the police department had been keeping an eye on a school gang that they were part of. They call themselves the Invisibles.
And who picked up whom?
I picked up the defendant, while Jones picked up Miss Patel.
Was it arranged like this for any specific reason?
Yes, ma'am. Jones had prior knowledge of Miss Patel, as he had worked a vandalism case that she had been part of. I, on multiple occasions, had already interviewed the defendant.
Now, why did you pick Miss Patel and the defendant up specifically?
We had received 2 anonymous tips earlier that morning that the defendant and Miss Patel had some sort of information relevant to the arson that we need to know in order to pinpoint who could have been responsible for it.
Now, did you receive permission to take both of the persons of interest to the crime scene?
Yes, ma'am. We received permission from both parents.
Were you notified of any special needs for either the defendant or Miss Patel beforehand?
No, ma'am. No one mentioned anything of that sort.
Was there any mention of medication?
No, ma'am. I heard nothing about medication.
Let the record reflect that I am now referring to what has been previously stipulated as Exhibit A, the map of Phillips, Ohio. Let the record further reflect I am presenting a clear and unmarked copy to opposing counsel. I believe your honors all have a copy.
We do, thank you.
May I approach the witness?
You may.
Thank you.
Detective O'Leary, can you please identify this exhibit for the court?
Yes, ma'am. This is a map of Phillips, Ohio.
Does that map accurately list the locations that you visited throughout your investigation?
Yes, ma'am, it does.
Now, where did you go that morning?
We took the 2 to the crime scene at the high school and to the victim's church over here and the victim's house.
Now, what sort of questioning techniques did you implement?
We encouraged them to tell us the truth. We let them know that 2 anonymous tips had come through, that they knew something relevant to the arson, and also that there was a eyewitness that gave us a general description that matched the 2 of them of 2 persons seen within the vicinity of the building.
And how did Ms. Patel and the defendant respond to this information that you gave them?
They denied it, as in my experience, all persons of interest do initially.
Now, Detective O'Leary, did you describe the seriousness of the situation to those 2 persons of interest?
Of course. I explained to them that Sheldon Brown's death had left a pregnant wife without a husband and 3 children without a father, and that it would be best for everyone if they were to simply tell us the truth.
Now, Detective O'Leary, did you at any time touch, put your hand on, or grab either Ms. Patel or the defendant during this part of your investigation?
No.
Objection leading, Your Honor.
Response?
Your Honor, Detective O'Leary is free to respond as she wishes to this question. It was not at all directed to a yes or a no specifically.
Objection will be overruled.
No, ma'am. My training strictly prohibits any physicality during an interview. Some time ago, I was reprimanded for that. I have learned my lesson, and I assure you it has not happened since.
Now, did Ms. Patel or the defendant make any different requests while visiting the locations?
No, ma'am, they did not.
Did they ask to call their parents?
No, ma'am. They didn't ask to call their parents nor an attorney, even though I made it clear that they could do so at any time.
But were the parents contacted ultimately?
Yes, ma'am. Ultimately, I contacted the parents as I felt that I should let them know how the interview was going, as well as I needed to ask them a few more questions, and so I would be taking them out for some lunch.
Now, did the parents make any requests during these phone calls?
No, ma'am. They did not.
So where did you go after you made the phone calls then?
That's when we took a break. We went to buy them some lunch and take a break.
Did you continue the investigation after your break?
We did. Yes, ma'am.
Why?
Based on my recent investigation training and subsequent investigation policy changes, I felt that this was now time to step up the pressure rather than to reduce it.
So then what questioning techniques did you implement following the break that you took?
We let them know that we had in our custody a hard drive that showed a video related to the maintenance building security camera, and that on that video there were 2 people seen in the vicinity of the crime, persons that matched their description.
Did you really have this hard drive?
We did, yes ma'am.
Now, Detective O'Leary, did you grab either of the persons of interest while questioning them at this point?
No ma'am, once again, that's against police protocol.
So where did you go from there then?
We split up. I took the defendant while Jones took Miss Patel.
So what sort of questioning techniques did you implement after you guys split up then?
I emphasized to the defendant that I knew she knew something about the arson and that it was very important that I obtain that information.
So how did the defendant respond to your techniques here?
She changed the subject, began speaking about Miss Patel and how she was angry at Mr. Brown.
Now, Detective O'Leary, did you grab the defendant during this part of your investigation?
No, ma'am. Once again, I'm strictly prohibited from doing so according to police protocol.
How did the defendant respond to your techniques as a whole?
I remember that quite clearly. She stated, "I started it and I never meant to kill anyone."
And what happened afterwards?
Well, her father pulled up, and once again she confessed to her father, saying, I did it, I'm so sorry, Daddy." After that, we took her into custody, filed felony arson and murder charges against her, got a signed acknowledgement of her Miranda rights, and placed her in a holding cell.
Now, what did you do as a result of these 2 confessions?
Well, once again, we just took her and put her in a holding cell.
How did you finish, and then what happened?
Well, about an hour later, her father and an attorney showed up to speak with her privately. After speaking to them privately, coincidentally, she recanted both of her confessions.
And then what happened?
After that, I ultimately had to rewrite the investigation report.
Why did you have to write it?
Well, Jones had originally wrote the investigation report, but our sergeant was worried about the report as it misrepresented our investigation techniques. And I was also concerned as I found false statements that he included within that report, statements I don't recall making nor hearing.
Just to clarify, Detective O'Leary, then, is it your testimony that Alex Jones put statements in that report that did not occur?
Yes, ma'am, that's correct.
And is it conceivable that Alex Jones could testify about those very same statements in court today?
I would count on it.
Now, was that the only reason why you agreed to write this report?
No, ma'am, I was also concerned about the tone of the report after I learned that Jones and the defendant's father are close personal friends.
Do you still work with Alex Jones?
No, ma'am. A few months after we worked this case together, Jones retired from the police force right before he was about to go into a disciplinary hearing regarding his reporting methods and also his refusal to use enhanced and proper investigation techniques.
Thank you. No further questions, Your Honor.
Ms. Badia, you may cross-examine the witness.
May I proceed?
You may.
Hello, Detective O'Leary. My name is Shivangi Bhatia, and I will be asking you a few questions.
All right, Ms. Bhatia.
Now, as you mentioned in the direct, you think that an empathetic and understanding approach is less successful than your own methods, correct?
Then a more direct approach, yes, ma'am.
Instead, you favor an in-your-face approach.
A very direct approach, that's correct.
And you consider this technique to be old school, isn't that right?
That's right. It also follows all police protocol.
And you use these techniques on Dakota Allen on September 22nd, isn't that right?
I use them on all persons of interest.
But on Dakota Allen, yes?
That's correct.
And you refer to them as your interrogation techniques, don't you?
They are used during interrogation, during interviews at all times.
So yes, they are your interrogation techniques.
As well as my interview technique, that's correct.
And you have gotten physical with a suspect before during an interview, isn't that right?
At the beginning of my 20-year career, it's true that I was reprimanded for it, but I have yet to do it since.
So that's a yes?
That's correct. I assure you it has not happened.
Detective, let's move on to the case at hand. You knew that taking this case might be advantageous, correct?
My sergeant told me that it would be, yes.
In fact, you were aware that it might help you receive a promotion, isn't that right?
I always like to believe I'm up for advancing my career.
So that's a yes?
My sergeant told me it would, yes, ma'am.
And you had a personal relationship with Mr. Brown, the victim in this case, isn't that right?
Yes, we grew up together.
And you had been friends since childhood?
That's correct. It's a small town. We all know each other here.
And you still considered him a friend during adulthood, isn't that right?
That's correct. We got together every once in a while.
And naturally, this caused you to get very upset over the news of his death, isn't that right?
I get upset over every murder I hear of.
But this specific one did get you upset, correct?
Yes, as with all.
And you even volunteered to contact Mr. Brown's wife about the tragic news, isn't that right?
That's correct, yes, ma'am.
Now, Detective, after picking up the suspects, you took them to the crime scene, correct?
Yes.
And at this point, you walked through the charred remains of the building?
Yes, ma'am.
And you came upon photos of Sheldon's family, isn't that right?
That's correct, yes.
And upon his burnt clothing, correct?
That's right.
Detective, you have been to numerous crime scenes before, correct?
I have, 20 years.
And you are generally unaffected by these crime scenes, isn't that right?
Generally, although some are worse than others.
However, upon arriving at this crime scene, you stated that you had a hard time putting your personal grief and anger aside. Isn't that right?
I did, but fortunately my training came through and I was able to keep my professionalism.
But that is a yes. You did have a hard time putting your personal grief and anger aside.
Initially, yes, ma'am.
And you were in a position to bring a quick resolution to this case, isn't that right?
As with all cases, we like to close them before it becomes a cold case.
But as you cited, you were in a unique situation, isn't that right?
That's right.
And you felt that this was a unique situation because it was the final respect you could pay to your friend Sheldon Brown, correct?
Yes, I find that finding the murderer is always a final respect.
Now, moving on. At 9 a.m., you drove past the victim's house, isn't that right?
That's correct.
And here, the suspects saw Sheldon's family and his pregnant wife, correct?
Yes, ma'am.
And Detective, driving past his house and seeing his kids really tore you up, didn't it?
Yes, ma'am. It's always difficult to see a mourning family.
And this was one of the hardest things you have ever done, am I right?
That's correct, but I still kept my professionalism.
Detective, you remember talking to Dakota's father on the phone, correct?
That's correct.
And you said during this call that no attorney was needed, isn't that right?
No attorney was needed, no.
And you said this because Dakota was not going to be charged with the crime, correct?
That's correct. At that point, we didn't have any evidence linking her to the crime. We just needed to know the information she had.
However, Detective, prior to this call, around 11 a.m., you felt that Dakota was approaching her breaking point. Isn't that right?
That's correct. I felt she was going to tell us the information that she had.
In fact, you felt she was close to giving you some kind of admission of being involved in the arson. Isn't that right?
Some sort of information or admission. It was possible that she could have given us
So
admission.
yes, an admission of being involved in the arson, Detective.
Or any information relevant to it.
Is that a yes, Detective?
Yes, as well as any information.
Now, Detective, throughout the interrogation, you continued with the mindset that the pressure should be increased. Isn't that right?
That's correct, yes, ma'am, as my training told me.
And Detective, at lunch, Detective Jones was of the opinion that you should terminate the interrogation and leave, correct?
Yes, he did believe that.
But you disagreed on this point, correct?
Yes, ma'am, my training told me it was time to step up the pressure.
In fact, this disagreement was based on your interrogation techniques and interrogation training and interrogation policy, wasn't it?
Yes, ma'am, I took a training that I don't think he did.
Now, furthermore, you wanted to make Dakota fear for her freedom during this case, isn't that right?
I felt that they were taking this as a game, and it was time to make sure they realized the severity of the situation.
So yes, you wanted to make Dakota fear for her freedom.
Fear for her freedom or feel some sympathy for the family.
So that's a yes, Detective?
Yes, or some sympathy.
Now, let's talk about your time at the restaurant. At this point, you mentioned to both suspects that you had recovered a hard drive, correct?
Yes, to the persons of interest.
And you claimed that this hard drive had a recovered video, isn't that right?
That's correct.
And this video showed 2 people committing the arson, am I right?
Yes, ma'am.
And you told the suspects that they matched the description of the 2 people in this video, isn't that right?
That's what we told them, yes.
Yet, this video had never been recovered, had it?
We had the hard drive, we had yet to recover the video.
Now let's go on to your one-on-one interrogation with Dakota. During this interrogation, you admittedly used a loud and angry voice.
During this interview, yes, it's part, you need to stay stern and tense with a person of interest in order to gain information.
And you told Dakota that she was involved in the arson.
Yes.
And this made you decide to continue with your in-your-face approach, am I right?
Yes, I felt that she still had yet to give me the information that we knew she had.
But Detective, you are aware that Dakota's only 15 years old, isn't that right?
Yes, I'm aware of that.
And you brought up Dakota's dead mother, didn't you?
Yes, ma'am.
And directly after that statement, Dakota confessed, didn't she?
Yes, she stated that she had started the fire.
After that statement, correct?
That's correct.
And you are familiar with the Miranda warnings, correct?
Of course.
And you always read them to suspects before taking them into custody, is that right?
Of course, as police protocol indicates.
And of course, you could recite these Miranda warnings to the court today, isn't that right?
You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. Is that correct?
Yes, that is. Now, you would say that these Miranda warnings that you just stated took less than a minute to state, correct?
Yes, I would agree with that.
In fact, less than 30 seconds, correct?
That's correct. 20 years experience.
Now, the total interrogation lasted 7 hours, didn't it?
Yes, ma'am. Interview.
Your Honor, I would like to introduce Exhibit C into the court. Note that I am showing opposing counsel a clean unmarked copy. Yes. Your Honor, this can be found on page 142 of your course materials.
Okay, thank you.
May I approach the witness?
You may do so.
Here you go. Now, Detective, can you tell the court what Exhibit C is, please?
Yes, ma'am. This was the signed acknowledgement that Dakota had known that her Miranda rights.
Now, this was signed exactly at 4:35 p.m. as it states on the form, correct?
That's correct.
And this was the first time you read Dakota her Miranda warnings?
Yes, that's correct. That she signed the acknowledgement of her Miranda warnings.
And can you please follow along as I read the first sentence on the form aloud?
Of course.
Before we ask you any questions, you must understand your rights. Did I read that correctly, Detective?
You did, yes, ma'am.
Thank you. No further questions.
Ms. Park, do you have any redirect?
Detective O'Leary, why didn't you read Dakota Allen her Miranda rights prior to signing that waiver?
Dakota wasn't in custody until after we read her Miranda rights.
Thank you. No further questions.
Any recross? Ms. Park, Mr. Hall, you may call your next witness.
The prosecution, would like to call Dr. Casey Highlander to the stand. May I proceed, Your Honor?
You may proceed.
Good morning.
Good morning.
Please state your name and occupation for the court.
My name is Casey Highlander, and currently I am a counselor at Phillips High School.
Dr. Highlander, what is your educational background?
I earned my bachelor's degree in psychology from the Case Western Reserve University. Following that, I earned my master's and PhD, both in educational psychology, from the University of Toledo.
And what did you do after you earned these degrees?
After I earned my degrees, I completed a 2-year supervised clinical internship with a practice in Phillips, Ohio. Following that, I was licensed to practice in Ohio, and then I established my own practice, Ohio Psychological Services, with several other local prominent psychologists. And after that, I came to work at Phillips High School.
What did you do as a practicing psychologist?
As a practicing psychologist, I diagnosed and treated various behavioral issues in children. I worked with a healthcare team to provide a unique treatment plan for each child.
And have you kept up with your practice?
Yes, I've published over a dozen articles in various child psychology journals.
As a child psychologist, are you familiar with Adeline?
Yes, I am. I've recommended its use a number of times in treatment.
Can you describe to the court what is Adeline?
Adeline is a medication primarily used to treat attention deficit hyperactivity disorder, or ADHD.
And as a child psychologist, do you have the occasion to recommend Adeline?
Yes, I've recommended its use a number of times in treatment as a practicing psychologist.
Do you work with Adeline in any other capacity?
Yes, a number of my students at Phillips High School are prescribed Adeline, which I administer to them, and I also monitor the effects.
And what is your role at Phillips High School?
My role at Phillips is to provide instruction, mentoring, or counseling for those students who may struggle with behavioral problems. Additionally, I administer medication and monitor the dosage.
And as a child psychologist, have you received any recognition?
Yes, I've actually twice received the Award for Excellence in Child Developmental Psychology from the American Institute of Psychologists.
Your Honor, at this time, we ask that the court recognize Dr. Casey Highlander as an expert in the field of child psychology pursuant to Evidence Rule 702.
Response?
No objection, Your Honor.
The witness will be so recognized. You can proceed.
Yes, Your Honor. Now, Dr. Highlander, how are you familiar with the defendant?
Well, Dakota is a regular visitor to my office as I administer her Adeline to her daily. Additionally, I've had the opportunity to counsel her on a number of occasions.
How did you first meet the defendant?
I first met Dakota in 2010 when her dad signed her up for the Phillips High School retreat. It's a 3-day retreat we do for all the incoming freshmen.
How would you describe the defendant's behavior at this retreat?
Well, Dakota and I got off to a very rocky start, but towards the end, she really got involved with some of the activities.
How would you describe her behavior during these activities?
I noticed that Dakota really seemed to excel at some of the survivor-style games. It was all in her strategic approach. She was calculating, intelligent, and confident, and that helped her succeed.
How would you describe the defendant's behavior at school?
At school, Dakota's behavior was also disruptive. We were scheduled to meet on a number of occasions her first year, and once when she was scheduled to meet with me, she posted an unflattering article about me on some internet site.
404, this is improper character testimony.
Response?
Yes, Your Honor. Dr. Highlander is not testifying as to any specific character trait exhibited by the defendant. She's not testifying that her actions conform to her character. Rather, she's testifying that the defendant regularly manipulates adults, and therefore, this is the specialized data off which she will later base her opinion as to the susceptibility of the defendant to influence by authority figures.
Your Honor, this testimony does not go to the truth of the character in question, and therefore is not admissible in court today.
May I be heard, Your Honor?
One last time.
It doesn't need to go to the truth because this is not character evidence. She's not testifying as to character traits exhibited by the defendant. She's testifying as to the defendant's behavior, and later she will testify as to how this behavior indicates that she is less susceptible than an average adolescent to undue influence by authority figures.
The objection will be overruled.
Thank you.
So, refinish, Dr. Highlander.
Yes.
All right, so how did this posting of the article affect your counseling?
It was nothing more than a distraction.
Can you describe your sessions with the defendant, your counseling sessions?
Sure. I would ask Dakota questions, and she was always very calm and thoughtful in her answers. She was very in control of herself the whole time.
Who would you say was in control of these sessions?
Sometimes Dakota was the one in control.
How would the defendant control your counseling sessions?
Well, she would pause and mumble, I don't know, if she didn't want to answer the question. She would engage in meaningless small talk, ask irrelevant questions, and try to change the subject.
And how would you describe the defendant's behavior compared to that of an average student?
Compared to an average student, Dakota was much more persistent and much more successful at limiting me from gaining control of the session.
And how successful were you in forcing the defendant to comply with your goals for these sessions?
Well, I tried numerous strategies to entice Dakota to cooperate, letting her have choices, letting her direct her own counseling, but oftentimes she would identify the technique and try to counter it.
So, Dr. Highlander, do you have an opinion within a reasonable degree of certainty as a practicing psychologist as to whether or not the defendant is more or less susceptible to coercion than an average adolescent?
Yes, I do.
On what do you base this opinion?
I base this opinion on my observations of Dakota around school and during our counseling sessions, as well as my experience working in the field of child psychology.
What is your opinion?
My opinion is that Dakota is very resistant to any type of questioning techniques. Adults and authority figures just don't seem to influence Dakota the way they can other adolescents.
All right, now let's talk about Adeline. What are the uses of Adeline?
Adeline is a medication primarily used to treat ADHD.
Objection, Your Honor. This is an improper opinion. As pursuant to Rule 702, a witness is only permitted to testify as an expert in her specialized field. Her specialized field is psychology, not psychiatry. Therefore, she cannot be permitted to testify to the medical effects of the drug.
May I respond, Your Honor?
Yes.
First of all, she's testifying as to a fact, the uses of Adeline, the withdrawal symptoms, the side effects. But even if she was testifying as to an opinion regarding Adeline, she would be qualified to do so, as she was recognized by this court to be an expert in the field of child psychology. She testified that as a child psychologist, she worked with Adeline. She recommended Adeline. She used it. She worked with a medical team to use Adeline to treat patients. She works with it on a daily basis. And therefore, even if this was an opinion, which it is not, she would be qualified to make that.
I think this falls within the scope of her expertise, but certainly you'll be able to cross-examine her and with regard to the limitations as to her opinion. You may proceed.
Yes, Your Honor. So, Dr. Highlander, what are the side effects of Adeline?
Side effects of Adeline can include headaches, panic attacks, or anxiety.
And what are the withdrawal symptoms of Adeline?
The withdrawal symptoms are actually very similar to the side effects, so there's little difference between what an adolescent can experience on the drug versus off the drug. And even in the most severe cases of withdrawal, there's rarely an effect on cognitive ability.
To your knowledge,
this is an improper opinion, as stated before, for the same reasons. She is not a medical doctor and cannot be permitted to testify on cognitive ability, as she never went to medical school.
Maybe here's Your Honor.
Sure.
In the previous objection, Your Honor overruled the objection as you found that within this testimony about Adeline was within her expertise, as she was qualified in child psychology, which she testified that as a child psychologist she worked with Adeline. So therefore, this is admissible.
If I may respond, working with Adeline is not equivalent to 4 years of medical school plus residency and all the necessary training required to become a medical doctor, of which Dr. Highlander is not.
The objection will be overruled for the same reason as my ruling with respect to the last objection. Go right ahead.
So Dr. Highlander, what difference is there between the withdrawal symptoms and side effects?
In some cases, there really aren't. And again, withdrawal, even in the most severe cases, rarely has an effect on cognitive ability.
So have you observed Miss Allen while she was on Adeline?
Yes, I have.
Have you observed Miss Allen when she was off Adeline?
On a few occasions, yes.
As a child psychologist, can you describe the difference in her behavior, if any, when she was on versus off Adeline?
Well, from what I've seen, for the most part, Dakota did not exhibit any sort of symptoms or behavioral changes when off Adeline.
Now, do you have an opinion within a reasonable degree of certainty as a child psychologist as to whether or not the defendant is dependent on Adeline?
Yes, I do.
On what do you base this opinion?
I base this opinion on my observations of Dakota both on and off the drug, as well as my experience dealing with Adeline as a practicing psychologist.
What is your opinion?
My opinion is that Dakota is not dependent on the medication. Her behavioral problems are environmental rather than neurological.
Now, to your knowledge, did the defendant ever use Adeline to get out of trouble?
Unfortunately, yes.
This calls for a leading question.
May I respond, Your Honor?
Yes.
It does not suggest any specific answer. She may answer as she wishes.
Can I hear your question again?
Does the defendant, to your knowledge, ever use Adeline to get out of trouble?
Objection will be overruled.
The statement was actually did instead of does. Thank you.
Okay, yes, Your Honor. So, Dr. Highlander, does the defendant ever use Adeline to get out of trouble?
Unfortunately, yes. She admitted to me that sometimes she will act out in class and then tell her teachers that she hadn't taken her medication that day. And in all of those instances, I found that Dakota had, in fact, taken her Adeline that day.
So does this mean that the defendant lied to her teachers?
Unfortunately, yes, to avoid the consequences of her actions.
Dr. Highlander, do you have an opinion as to the truthfulness of the defendant?
Yes, I do.
What is that opinion?
My opinion is that Dakota can engage in deception, manipulation, or misrepresentation if she wants to. In other words, I guess she's untruthful.
And in what circumstances does the defendant engage in this deception?
She typically does this when facing disciplinary action.
No further questions.
Counsel, I didn't hear the pronunciation for your last name.
Wall.
Wall?
Yes.
Okay, go right ahead.
Thank you. Good morning, Dr. Highlander. My name is Evan Wall, and I will be asking you several questions today.
Good morning.
Can we begin by discussing your background?
Sure.
You received your master's and PhD in educational psychology from the University of Toledo, correct?
That's correct.
And just to clarify for the court, you are a psychologist, not a psychiatrist, right?
That's correct. I have a PhD.
So therefore, you never attended medical school or received any medically accredited training. Is that right?
No, I'm a psychologist. I spent many years working on my master's and PhD.
And you have never prescribed the drug Adderall, correct?
No, but I can recommend it, and I have recommended its use a number of times in treatment.
That wasn't my question, doctor. I simply asked, have you ever prescribed the drug?
Specifically prescribed, no.
Thanks. Now, despite this lack of formal medical education, you testified that Adderall users can have side effects, such as headaches, panic attacks, and anxiety. Is that right?
Yes, those are the possible side effects.
And that Adderall users can exhibit withdrawal symptoms similar to these side effects when use is stopped. Is that right?
That's correct.
And there was one particular instance in which Dakota's lack of medication may have had a significant impact on her. Is that right?
I do recall that instance, and in that situation, I want to be clear that there's no way to know whether or not Dakota took her medication at home in the morning or if it really was a lack of medication.
Sorry, doctor. I think you misunderstood my question. I simply asked if you were aware of this incident.
Yes, I am aware.
Thank you. And in this particular incident, Dakota began by screaming at another student for no apparent reason. Is that right?
Yes, she was acting very dramatically in the hallway, and that's how I found her, yes.
And then she began crying, talking to herself, and demanding medication. Is that right?
Yes, as I said, Dakota can be very dramatic.
And then she actually claimed responsibility for pulling a school fire alarm. Is that right?
Yes, she did.
And did she pull that fire alarm?
Well, there were another student had actually come forward with that information earlier in the day. So when Dakota claimed responsibility, I had a bit of a dilemma as there were two students who both claimed responsibility for pulling the false fire alarm.
Doctor, is that a no? She did not pull his fire alarm?
Well, I really can't say.
But another student did come forward and claim responsibility before Dakota. Is that correct?
Yes, Dakota had arrived late to school that day.
And after you administered her medication, like she asked, she calmed down, right?
Actually, she took her medication, she had some time to rest in my office, and then she appeared to have calmed down.
And she then returned to her normal state, as you described it. Is that correct?
Yes, she appeared to.
So, therefore, Dakota has falsely confessed in the past, right?
I would not call that a false confession. She tried to claim responsibility for what she must have thought was a school prank.
You said Dakota was not at school that morning, correct?
She missed her morning appointment, yes.
And therefore, she couldn't have pulled their fire alarm, right?
She could have pulled the fire alarm.
But another student did come forward, is that correct?
This is asked and answered.
This is cross-examination. I'm going to allow him to continue.
Would you like me to repeat the question, doctor?
If you wouldn't mind.
Another person did come forward claiming responsibility for the act. Is that correct?
That's correct.
Thank you. Now, doctor, are you familiar with the basic facts of the case at hand?
I've heard Detective O'Leary testify, yes.
So generally, you are aware of the facts, as you were not sequestered, correct?
That's correct.
And are you aware that in this case, Dakota confessed to a crime only to later recant that confession after receiving medication?
Yes, I guess Dakota might be blaming her behavior on a lack of medication.
And doctor, regardless of your educational background or interactions with Dakota, you were not in the back of the police car with Dakota during the 7-hour interrogation, were you?
I was not there with Dakota, but I have seen Dakota in a variety of different situations.
But you were not there in the back of the police car, were you?
I was not there that day, no.
So you have no way of knowing for sure how she acted in that situation?
Well, I've seen Dakota in a variety of situations.
Doctor, I'm asking about this situation. You have no way of knowing for sure how she acted in this situation in the back of a police car, do you?
I did not see her, but I have seen Dakota in many other situations.
Doctor, I think you're misunderstanding my question still.
Your Honor, this is asked and answered. The witness has provided a yes response.
Response?
She has not provided a yes or no response, Your Honor.
I'll overrule the objection.
Would you like me to repeat the question one more time?
If you wouldn't mind.
Now, you were not there in the back of a police car, were you?
I was not there that day, no.
So therefore, you have no way of knowing for sure how the defendant would have acted, did you?
I can't say with 100% certainty.
That's a no, doctor. You have no way of knowing for sure.
I can make a pretty good guess of how she acted.
I'm not asking about your guess. I'm asking if you knew for sure.
I did not specifically see her.
No further questions, Your Honor.
Any redirect?
Yes, sir. Right there. May I proceed, Your Honor?
Yes.
All right. Dr. Highlander, do you have an idea of how the defendant acted that day?
Well, I've been Dakota's counselor for 2.5 years. Dakota has gotten into trouble over those 2.5 years, so I know what Dakota acts like in a variety of different situations.
How does Dakota act when confronted by authority figures?
Well, if Dakota finds that she's facing disciplinary action, she can misrepresent situations. She will sometimes lie about not having taken her medication to get out of consequences.
Would you be surprised if the defendant misrepresented the situation here today? Your Honor, I'm simply asking whether or not she'd be surprised, not whether or not that's actually going to happen.
Objection is sustained.
Yes, Your Honor. Dr. Highlander, opposing counsel asked you about the withdrawal symptoms and side effects of Adeline on cross-examination. Do you remember that?
Yes.
Can you describe to the court the difference between those two things?
Well, the side effects and withdrawal symptoms are actually very similar, and from my experience, especially dealing with Dakota, there's really little difference between what she experiences while on the drug versus off the drug.
So hypothetically, if Dakota were to be off Adeline, how would this impact her mental processes?
Objection, Your Honor. This answer calls for speculation once again.
May I respond, Your Honor?
Yes.
This calls for an expert opinion. She was qualified in child psychology, so therefore she may make this expert opinion. Pursuant to Evidence Rule 705, witnesses may testify in the form of hypothetical questions.
Objection is sustained.
Yes, Your Honor. So, Dr. Highlander, how would you describe the defendant's reaction to being accused of a wrongdoing?
Well, she can misrepresent situations or engage in deception.
No further questions.
Any recross?
Yes, briefly, Your Honor. No. Doctor, on the redirect examination, you mentioned Dakota's familiarity with authority figures, correct?
Yes.
However, you have never interviewed Dakota during a police interrogation, have you?
I've never interviewed Dakota during a police... No, I'm not a police officer.
Right. So therefore, you have no way of knowing for sure how she would act in a police interrogation, would you?
Well, I've seen Dakota in a variety of situations.
Doctor, again, I think you're misunderstanding my question. You have no way of knowing for sure how she would react during a police interrogation, would you?
Well, actually, I have observed Dakota being questioned by a school security guard, so...
But not a police interrogation in the back of a police car, have you?
I've never seen a police interrogation in the back of a police car.
With Dakota?
With Dakota.
No further questions.
You may step down. Does the state have any additional evidence to present at this
Your Honor,
time?
the prosecution rests at this time.
A defense?
Your Honor, at this time, we'd like to call defendant Dakota Allen to the stand. Hi, Dakota. It's good to see you again.
It's good to see you too.
Please state your name, age, and occupation for the court.
My name is Dakota Allen. I'm 15 years old and I'm a student.
Let's begin by discussing your background. Where do you live?
I live in Phillips, Ohio with my dad.
And your mother?
She died in a fire when I was 10.
And how are you dealing with that?
I miss her terribly. And doctors say I have unresolved anger issues, which I take Adeline for.
Objection, Your Honor, as improper opinion and hearsay. Excuse me. Ms. Allen citing the reason as to why she takes her Adeline is an improper opinion, as she has not been qualified as anything relating to medicine. On another note, it is also hearsay because the doctors telling her prescription and her illness is also an out-of-court statement used to prove the truth of the matter asserted.
Response?
Yes, according to Rule 701, a late witness may provide her opinion given that it is reasonable with her knowledge, and since she was prescribed the drug, she does have knowledge of this instance.
May I respond, Your Honor?
Sure.
Mr. Wall has still not responded to my objection as to hearsay, however. Regardless of whether or not she may make an opinion as to this matter as a late witness, it is still an out-of-court statement used to prove the truth of the matter asserted and therefore inadmissible in court today.
I agree with your argument, Ms. Park. The objection is sustained.
Thank you. Move to strike, Your Honor.
Motion to strike is granted.
Dakota, what trouble, if any, have your unresolved anger issues gotten you into at school or with the police, perhaps?
Well, my friends and I sometimes mess around at school, but we've never gotten in trouble for anything serious.
Okay, now let's move to the morning of Saturday, September 22nd. Please take the court through the events of the day. What first occurred that morning?
Well, I was awoken by Detective Sam O'Leary knocking at my door, and before I could go back to sleep, I got a text from Quinn saying that police had wanted to question her about some fire that I had never heard anything of.
And what did the detective want from you?
She wanted to interview me. My dad gave her permission. He said he was done dealing with my screw-ups, so I had no choice but to go with the detective.
So you went with the detective, and what happened next?
Well, she ordered me into her car, and we drove really fast to Quinn's house. She seemed really annoyed the whole time. And we got to Quinn's house where Detective Jones and Quinn were waiting. We all got in the car together, and we drove to the school grounds. I remember feeling really scared, disoriented, and nauseous, and on top of all that, I hadn't taken my medication.
I respectfully object as to relevance. According to the Supreme Court case of Yarbrough v. Alvarado, the determination of a custodial interrogation involves no consideration of the suspect, or in this case, the defendant's actual mindset or feelings.
Response?
Your Honor, according to JDB v. North Carolina, the defendant's mindset does come into effect, in addition with Haley v. Ohio.
Your
That is false.
objection is overruled.
Dakota, would you like me to restate the question?
Yes, please.
So, after being taken to the car, how were you feeling?
I was feeling scared, disoriented, and nauseous, and on top of all that, I had not taken my medications.
And why hadn't you taken your medication that morning?
Well, I had just woken up. I didn't even think to bring any.
Now, you were at the scene. What did you see there?
The school storage building was smoking. There was yellow police tape everywhere, and it smelled terrible. I figured this was the fire the police had been talking about.
And what did the detective say, if anything, about what might have caused the fire?
Well, Detective Jones told us that 2 anonymous tipsters had told them about 2 people who they thought knew something about the arson, and O'Leary told us that an eyewitness had described those 2 people to look like me and Quinn. They started peppering us with all these questions, and Detective O'Leary was talking in a really loud, angry voice like we were in a street gang or something.
And Dakota, how did you respond to these accusations?
I asked if we were under arrest, and they said no, but then they ordered us out of the car to walk around the scene.
And please describe for the court what you saw there.
It was terrible. I saw the white chalk outline of a body on the ground, and as we got closer, Detective O'Leary showed us a photograph of a family. I recognized the man in the photograph as Sheldon Brown. He was our school maintenance worker. Detective Jones told us that he was the one who died in the fire.
And how did this make you feel?
I felt so sick I started dry heaving. That family in the photograph looked so happy. My family might have looked like that if my mother hadn't died. Mom died by a fire too. We denied any knowledge or involvement in the fire, but I could tell that O'Leary didn't believe us.
So after taking you to the scene of the crime, where did you go next, Dakota?
Well, they drove us around a nearby neighborhood, and the whole time the detectives kept telling us to tell the truth and that they knew we were hiding something. And then finally we stopped near the house where Sheldon Brown and his family had lived. There were tons of people there, many of them crying, and I recognized 2 of the kids in the yard as ones from the photograph.
And at this point, how were the detectives trying to get you to cooperate?
Well, Detective Jones told us that our families would love us no matter...
As to lack of personal knowledge, although Ms. Allen may testify as to what the detectives were doing, Mr. Wall cannot identify it as something that the detectives were utilizing for that specific purpose alone.
May I rephrase, Your Honor?
Yes, you may.
What were the detectives doing at this time?
Well, Detective Jones told us that our families would love us no matter what as long as we told the truth. Detective O'Leary told us that things could get very ugly very quickly if we didn't tell the truth. Detective Jones also told us that we could help the family by giving them closure. Closure's a good thing. I wish I had closure on my mother's death.
And how was this making you feel?
I was getting angrier and angrier at their accusations. I asked them to have my dad bring me my medications, but they just laughed at me. I also had to go to the bathroom, but they refused that request too.
So instead of going to get your medication or going to the bathroom, where were you taken next, Dakota?
We were taken to the cemetery where Sheldon Brown was to be buried. I could see the workers digging the fresh burial site. It was the same thing over and over again, accusation, denial, accusation, denial.
And Dakota, what was significant about this particular cemetery?
It was a cemetery where my mother was buried. I could see her headstone as we drove in. I was getting really depressed really fast. I just didn't understand what Mom's death had to do with some fire.
And where were you taken next?
Then finally, after hours of interrogation, we were taken to a fast food restaurant where we were escorted to the bathroom, and then we were ordered back into the car.
And how were you feeling at this point?
I still felt like I needed my medications. I felt like I was in some courtroom drama, and the badgering wouldn't stop until someone confessed.
Now, when you were brought back to the detective's car, what new information, if any, did Detective O'Leary have regarding the case?
Well, she said that she had surveillance footage from the school storage building security camera of 2 people breaking in through a window, and she said that those 2 people looked like me and Quinn.
And how did this new information impact you?
I felt so sick I threw up out of the window. I just didn't understand why everyone thought I started the fire.
And what happened next?
Well, then Quinn and I were split up, and Quinn went with Detective Jones, and I went with Detective O'Leary. I thought they were going to take us home like I wanted them to, but instead O'Leary drove me back to the school grounds.
And once back at the crime scene, what did Detective O'Leary say to you?
She started talking about how she thinks it's me on the surveillance video, how she would find my fingerprints at the crime scene, she called me a fire starter, and how Quinn was going to take some plea deal that ratted me out. I was getting really scared and really angry.
And what did the detective do next?
She grabbed me and yelled at me that she didn't want to have another unsolved arson on her record.
And what was your understanding of the arson that she was referring to?
The fire that killed my mother.
And how was the detective reacting to this?
She grabbed me, started shaking me, and slapped me, and told me that my mother would love me more if I told the truth. Detective O'Leary didn't even know my mother. Finally, Detective Jones and Quinn came back to the scene, and Detective O'Leary took her hands off of me.
And Dakota, how did you react to this assault?
I lost it. I started screaming, and I said I did it, even though I didn't, because I wanted everything to stop. The next thing I knew, I saw Dad drive up, and I was in handcuffs getting out of a car at the jail.
And what were you charged with?
Arson and murder, which I had nothing to do with.
Now, please take the court through the events that transpired at the jail.
Well, my dad arrived, and I was finally able to take my medications. I felt right again, clear. I ate. Then I told the attorney that I had nothing to do with that fire. The detectives wouldn't get me my medications, and Detective O'Leary shook me and slapped me.
So, Dakota, why did you confess?
I had nothing to do with that fire. I only said what I did to make everything stop, because I knew that I wouldn't unless I told them what they wanted to hear, even if I had nothing to do with the fire.
No further questions at this time, Your Honor.
Ms. Park, you may cross-examine the witness.
Good morning, Miss Allen. Let's talk a little about the investigation, okay?
Okay.
Detective O'Leary came to your house at 7 o'clock in the morning, right?
Yes, she did.
And Quinn texted you that morning, warning you that the police officers would be there to ask you a few questions about an arson, right?
Yeah, I had no idea what she was talking about.
And you actually forwarded that text to your other friends, didn't you?
Yes, I did.
And in fact, Dakota, you had your phone the whole day, didn't you?
I had it with me, but there was no way I could use it.
You had your phone though, right?
I had it, but I didn't feel comfortable enough to
And the
use
police
it.
officers never tried to take that phone away from you, did they?
I don't think they even knew I had my cell phone.
Is that a yes, Dakota?
They didn't know I had it, so no, they didn't take it away.
Now, this actually wasn't the first time that you had met Detective O'Leary, right?
I met him once, and she asked me a couple questions.
Right, she'd interviewed you about vandalism beforehand, hadn't she?
Right, she asked me a couple questions.
Now, your dad actually gave us permission for Detective O'Leary to investigate, right?
Yeah, he was angry and said he was done dealing with all of my screw-ups, so I had no choice but to go with her.
That's a yes, right, Dakota?
Yes.
Now, throughout this investigation, you were in an unmarked police vehicle, right?
It was unmarked, but it still had a police radio, it had lights, and a police computer.
That's a yes, right, Dakota?
It wasn't marked, no.
And the detectives weren't wearing their full police uniforms, only their jackets and their holsters, right?
Yeah, they had their gun in their holster, yeah.
Now, the detectives actually told you about 2 anonymous tips that you brought up on direct examination, right?
They told us about them, yes.
And you asked them if you were under arrest, didn't you?
I did ask.
And they actually said that you weren't, right?
They said I wasn't, but I wasn't sure if they were telling the truth.
But, Dakota, then you lied to the detectives, didn't you?
Can you give me the specific instance?
You told them that the night before the fire, you were at your house with Quinn, right?
Oh, yes, when I told them that I got my nights mixed up, and I told them that Quinn was at my house.
Right. You actually lied to them and told them that you and Quinn were at your house when you were actually down by the fire, right?
Yes, I misspoke, and I told them the wrong thing.
Now, this wasn't the only time you lied, though, was it?
Can you give me the specific instance?
Actually, at the police station, when you were talking to your attorney, you told your attorney that you weren't allowed to go to the bathroom throughout the investigation, right?
Yes, I did say that.
But you did go to the bathroom, didn't you?
Yeah, we were escorted to the bathroom.
Regardless, you were allowed to go to the bathroom, right?
Yes, we were.
And this was actually at the fast food restaurant, right?
Yes.
Now, that wasn't the only thing you told your attorney, right?
No, I told him a number of other things.
Including the fact that Detective O'Leary had apparently slapped you, right?
She did slap me.
Now, in your own witness statement, this is the only time that you talk about being slapped, right?
Yes, it is. I told my father exactly what happened, and Detective O'Leary slapped me.
But when you're detailing what's happening inside of the car, you don't mention being slapped a single time, do you?
I mentioned it when I told my father, when I was telling him and the attorney exactly what happened.
Right. Now, Dakota, in your own words, sometimes your fantasies seem real, right?
Yes, every once in a while I get fantasies about my mother.
That's a yes, right?
Yes.
Now, let's go back to the fast food restaurant.
Yes.
They let you go to the bathroom there, right?
Yes, they escorted us.
And you ate in the car, right?
I had a couple fries, yeah.
You ate in the back.
In the back of the police car.
The detectives were not in the car, right?
They weren't with us, so I saw them talking to their other police friends.
They weren't sitting back there. They weren't sitting in the front. You were actually alone in the car with Quinn, weren't you?
Yeah, I was alone in the car with no way of getting out.
And it was in the back of the car that you actually had your cell phone that you had the entire day, right?
I had my cell phone, but again, I didn't feel comfortable enough
Regardless,
to use it.
Dakota, you had your cell phone with you in the back of the car, right?
I had it with me, yes.
And you could have used your cell phone, couldn't you?
No, I didn't feel like I could have used my cell phone.
But you could have, regardless, right? If you had your cell phone with you and you were in the back of the car, you could have used it, right?
I didn't feel comfortable enough because I saw the police right there and I didn't want them to see me.
It's not whether or not you felt comfortable, it's could you have used your phone?
I suppose I could have, but again, I didn't feel comfortable enough to.
It was then that Detective O'Leary gave you some more information about this case, right?
Yes, he did. She did.
She actually told you that she'd recovered a video from the security building's camera that showed you and Quinn, right?
Yes.
But you weren't interested, were you, Dakota?
I was. I felt so sick about that, I threw it out of the window.
In fact, before that, you actually told Detective O'Leary to have a nice day, right?
I did tell her that.
But it was then that the detective took you back to the building, right?
Yes, she did.
And that was where your dad met up with you, right?
Yes, he did.
But before your dad picked you up, you said something, didn't you, Dakota?
I said some things, yes.
You actually said, "Stop talking to me. I started it. I never meant to kill anyone. I just wanted them to pay attention to me," right?
When I said those words, it wasn't myself saying them. I needed to get out of that situation as fast as I can.
Is that what happened?
I said those words, but I didn't mean them.
And when your dad arrived at the scene, you said, I did it, and I'm so sorry, Daddy, right?
Again, I heard myself saying those words, but I didn't mean them.
It's not whether or not you heard yourself, you said those words, right?
Those words did come out of my mouth.
Now, you brought up your medication on direct examination, right?
Yes.
And you claimed that you wanted your medication during your questioning, right?
I did. I needed my medication.
And you actually asked both Detective O'Leary and Alex Jones, while they were both in the car with you and Quinn, for your medication right after lunch, right?
Yes, and they laughed at me.
And this medication, the lack of it had a huge impact on you, didn't it?
Yes, it did.
And not having your medication, that was a pretty big deal, right?
Yes, I really needed my medication, and when I asked, they laughed at me and ignored me.
But, Dakota, you don't take your medication every day, do you?
On occasion, I will skip a couple days.
That's a yes, right?
On occasion.
And in fact, sometimes, according to your own words, you choose not to take that medication, right?
Again, on occasion, I sometimes...
Is that a yes or a no, Miss Allen?
That is a yes.
On the day before the questioning, for example, you hadn't taken your medication, had you?
No, the day before I hadn't taken it.
And you feel like a Stepford child when you're on that medication, right?
Yes.
You state that you get tired of this absence of feeling when you're on your medication, right?
I do. Having to take medication 3 times a day makes me not feel like myself.
In fact, Dakota, you even call your own medication goners, don't you?
I sometimes exaggerate and call them that.
And in your own words, you feel more real when you're not on your medication, right?
That's absolutely true.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Now, Dakota, on the morning of Saturday, September 22nd, why did you not take your medication?
Well, it was 7 o'clock on a Saturday morning. It was much earlier than I usually get up on Saturdays, and I just didn't think to bring my medication.
And what was the detective's response when you asked for your medication?
They just laughed at me and ignored the request.
And how did this then make you feel about using your cell phone?
I didn't feel like I could use it.
Your Honor, this is an invention of fact. Nowhere in Ms. Allen's witness statement does it identify why she felt uncomfortable using her cell phone.
Your Honor, according to Rule 701, again, a lay witness may provide her opinion if the basic facts are there. And in this case, the reason that she didn't feel she could use her cell phone is because the detectives ignored her request for her medication.
May I respond, Your Honor?
Yes.
Invention of fact is a mock trial specific rule that prevents any team from gaining an unfair advantage over the other. It is not permissible on direct or redirect examination, and this is an extrapolation from the witness statement, which Ms. Allen is bound by on redirect examination.
I think it is an extrapolation, and this is direct examination. Objection will be sustained.
Yes, Your Honor. Motion to strike, Your Honor.
Motion to strike will be granted.
Now, Dakota, why did you confess?
I had nothing to do with that fire. I was in a very intense situation that I needed to get out of, and I knew that I couldn't get out of it unless I told the detective what she wanted to hear, even if I had nothing to do with the fire.
And again, what did Detective O'Leary do to you to make you confess?
She shook me, and she slapped me.
No further questions.
Any recross?
May I ask the timekeepers how much time is remaining? No recross, Your Honor.
Okay. The witness may step down.
Thank you.
The defense may call your next witness.
Your Honors, the defense would like to call Detective Alex Jones to the stand. May I proceed?
You may proceed.
Hello, Detective Jones. Can you please state your name and profession for the court?
Alex Jones, former detective.
And can you please give a brief timeline of your experience and background?
Certainly. I've been a police officer for the past 11 years, a detective for 7 of those years, and I've spent the past 5 years in the homicide unit. Prior to that, I was a social worker at Phillips Juvenile Detention Center for 5 years.
You mentioned the homicide unit. Who else worked with you?
Detective Sam O'Leary for all 5 of those years.
And how would you describe your relationship with Detective O'Leary?
And it's never very good. We had our fair share of differences. She never respected my social work approach or my official police write-ups, and she was a black and white girl, like a yes and no kind of girl. Ultimately, I learned what not to do when interrogating suspects from her.
Detective, let's move on to the case at hand. What occurred on Saturday morning, September 22nd?
Detective O'Leary and I were assigned to the arson fire that had occurred the previous night in the maintenance building behind Phillips County High School, which unfortunately resulted in her friend's death and janitor Sheldon Brown.
What was your reaction to getting assigned to this case?
You know, it was unusual. It's not typical that we get these kinds of cases. It was inappropriate, actually.
Why did you feel it was inappropriate?
Well, both Detective O'Leary and I had personal involvement in the case. I knew the defendant's father from a previous instance, and Detective O'Leary seemed to have a very intense interest in the case as her dear friend passed away in the fire.
So after you eventually accepted this case, what happened?
We picked up both Dakota and Quinn from their houses. I picked up Quinn, and Detective O'Leary picked up Dakota.
And upon arrival, what did you tell Quinn's parents?
I told them that some tipsters had given us information, that they knew something about the fire, and that we needed to ask them a couple questions, take them to a couple crime scenes, and that we'd only be a couple of hours.
What happened next after the pickup of both Dakota and Quinn?
We took both of them to the crime scene where almost immediately Detective O'Leary said that lying would only make things worse. We saw that we walked through the charred remains, and then he went on to tell them that he vividly described the death of Sheldon Brown, as being trapped by a firestorm and choked by smoke. It was definitely pretty intense from the get-go.
What happened next?
She told them that some tipsters had given us information that they knew something related to the fire, and that there was an eyewitness account of 2 people who were at the crime the previous night.
With this information, how did the defendant reply?
Not very well. She started to cry uncontrollably, and her emotions seemed all over the place. But both kids denied any involvement at all in the crime.
Detective, what happened next around 9 a.m.?
We took the kids past the victim's house, where we saw grieving family members in the front yard, and Detective O'Leary made it a point to emphasize the tragedy it was that Sheldon Brown had suffered and what his family would go through. She then told the kids that some, she told the kids that we would not stop until we found out what had happened.
And what else did she continue to do?
She started to bang on the steering wheel and curse at the kids. She even pointed her finger in their faces and said that lying would only make things worse for them.
How would you describe this outburst and your perceptions?
Truthfully, I couldn't tell if it was genuine anger or if it was a tactic used by him to scare the girls, but it was out of line in my opinion.
Objection, Your Honor, as to improper opinion. Ex-Detective Jones just testified that this behavior by Detective O'Leary was out of line, thus indicating that it did not follow protocol, but Detective Jones was not qualified in any expertise related to such interviewing techniques.
May I respond?
Yes.
Your Honor, pursuant to Rule 701, detective is a lay witness and is allowed to give his perceptions upon the case as it clarifies the testimony and the facts of this case.
Yes.
In order for a witness to testify as a lay witness and give his or her opinion, that opinion must be rationally based on the perception of the witness. This opinion that it was out of line requires not just perceptions, but also knowledge of protocol, expertise on protocol, and therefore this is outside of the scope of Evidence Rule 701. This requires an expert opinion pursuant to Evidence Rule 702.
The objection is sustained.
All right.
Motion to strike is granted.
Let's move on. So after this outburst, what happened at 11 a.m.?
We took the kids past the victim's church and graveyard, where we saw the fresh burial site of Sheldon Brown. And once again, Detective O'Leary made it a point to emphasize the tragedy it was that Sheldon Brown had suffered and, again, what his family would go through. At this point, he said we would not stop this interrogation until we found out exactly what had happened.
How did the defendant reply to these statements?
She said she had a headache and mentioned something about medication.
How did you respond?
Well, I pulled Detective O'Leary to the side and said, maybe we should take Dakota home, get her some medication, and if need be, we can resume interrogation after.
And once you mentioned this, what did Sam say?
Unfortunately, she ignored me and told the kids that we were awaiting lab results for an accelerant that was used in the fire, and that if it linked either of the kids to the crime, then any cooperative deals would be thrown out of court. Now, I've been a police officer for the past 11 years, and neither Detective O'Leary nor I have the authority to make that statement. Only the prosecutors do.
So during this part of the interrogation, how did Dakota react?
Again, not very well. She asked to be taken home and said she just needed her medication.
Did Detective O'Leary agree to take her home?
At first she did, but she later simply made a phone call to her father.
And what did she say during this call?
She said that no attorney was necessary because they weren't going to be charged in the crime, and she failed to mention anything about the medication, which was the purpose of the phone call.
And after this call, what did you realize?
That he was out to arrest either one or both kids by the end of...
Your Honor, as to lack of personal knowledge, Mr. Jones just testified that Detective O'Leary was out to arrest one of the children. First of all, this is a lack of personal knowledge, as there's been no evidence sufficient to support a finding that he has personal knowledge of the subject. Furthermore, it is irrelevant, as in the case of Stansbury v. California, the Supreme Court held that the unarticulated views harbored by either a detective are irrelevant to the determination of whether or not a custodial interrogation occurred.
May I respond?
Yes.
Your Honor, Detective Jones has been a detective for 11 years. He knows the police protocols. And again, pursuant to 701, this is a perception that he's giving as a lay witness as to what he believed in his knowledge as a detective for 11 years again.
I've heard both sides. The objection is sustained.
Yes, Your Honor. Move to strike.
Motion to strike is granted.
Let's proceed. Now, Detective, at 12 p.m., how did you proceed with this interrogation?
Like you said, it was around 12 p.m., and it had been 5 hours at this point, so we took them to a fast food restaurant where we got them some food, and we then resumed interrogation. Detective O'Leary, at this point, outright lied and said we had a hard drive with video evidence of 2 people who were at the crime the previous night who matched the kids' descriptions.
How did the defendant respond to this?
Not very well. She threw up out the window and once again asked to be taken home.
So after you witnessed these lies from Detective O'Leary, what did you do?
I pulled Detective O'Leary to the side and said, listen, things had gone on too far and we got to take these girls home. They've been consistent in their stories.
Objection, Your Honor, as to relevance. The conversation held between Detective Jones and Detective O'Leary is irrelevant, as it was not within earshot. As he said, he pulled Detective O'Leary to the side. It was not within earshot of the defendant, and therefore it would not impact how a reasonable person would perceive his or her freedom to leave.
Your Honor,
Your response?
I believe it is imperative that Detective Jones establish the conversation between himself and Detective O'Leary, as it is going towards the facts of this case, and will further on be explained.
Yes.
This is, regardless, an unarticulated subjective view harbored by the detectives. This is a conversation that was not heard by the defendant and therefore would not impact how a reasonable person would perceive his or her freedom to leave, regardless of whether or not Ms. Bhatia believes that it is important. It has no basis in the issues.
Let me hear your question again.
My question was, so after you witnessed these lies from Detective O'Leary, what did you do?
Objection is sustained.
Yes, Your Honor. Move to strike.
Motion to strike is granted.
So what occurred next?
Detective O'Leary and I split the kids up and interrogated them separately.
And after you did this, what occurred?
Well, we reconvened at the crime scene, and Detective O'Leary, I saw her shouting in Dakota's face and violently gesturing his hands.
And what occurred after you witnessed this outburst?
I got out of the car and I approached her car, and that's when Dakota confessed to committing the crime. Detective O'Leary went off to the side to cool off.
Where did you take Dakota after this confession?
We took her to the police station where, for the first time, she was read the Miranda rights. The whole time, she seemed pretty dazed and confused, but her father did arrive with medication and an attorney as well.
What did her father do with this medication?
He gave it to her.
And what effect did this medication have on Dakota?
She seemed to be doing a lot.
Objection, Your Honor, as to improper opinion. Mr. Jones was not qualified in the field of child psychology or anything that involves the effect that medication has on children, and therefore this is not within his bounds to make this statement.
May I respond?
Yes.
Your Honor, again, pursuant to Rule 701, this is a perception. He was there during this event. He witnessed the outcome after Dakota took the medication. Therefore, this is his perception upon what occurred.
May I respond, Your Honor?
The objection to the question is sustained. You can ask what the witness observed after the medication was taken. You're asking what effect the medication had, and I don't think he's qualified to answer that question.
Yes, Your Honor.
So, Detective, what occurred after Dakota took the medication?
Again, she seemed to be doing a lot better, and she recanted the entire confession and denied any involvement at all in the crime.
Thank you. No further questions at this time.
Cross-examination.
Yes, Your Honor. May I proceed?
You may proceed.
Good morning, Mr. Jones.
Good morning.
Now Sam O'Leary was your partner for 5 years, isn't that right?
That's correct.
But as you said on direct examination, your relationship with Detective O'Leary was never very good, was it?
Absolutely not. We disagreed several times on interviewing and interrogation techniques.
Exactly, and not only that, but at the time of this interview, you and Detective O'Leary were up for the same promotion, isn't that right?
Yes, and I was not surprised that she was complaining behind my back to the sergeant and chief of police, her father-in-law.
Objection, Your Honor, as to non-responsive. My question didn't call for any response involving Detective O'Leary's actions behind Detective Jones's back.
Response?
Yes, Your Honor. I believe my witness did respond to the question.
Objection is sustained.
Yes, Your Honor. So, Mr. Jones, that's correct, that you and Detective O'Leary were both up for the same promotion.
Yes, and she was complaining behind my back.
Your Honor, once again, I object. This is the same answer offered previously. I have a limited amount of time on cross-examination.
Response?
Your Honor, I believe this is imperative that this detail be stated along with the yes that was given.
The explanation that's being offered is not required to answer the question. Objection is sustained.
All right, so that's a yes.
Yes, she was complaining behind my back.
Isn't that true that you knew the defendant's father prior to this investigation, right?
I knew him from a previous instance.
Right, you'd investigated a vandalism case involving the defendant. Isn't that right?
Yes, that's correct, which the charges were later dropped because of the negative impact of her medication.
Right, the charges were dropped in that case because of the negative impact Dakota's medication had on her.
Right, she never took the medication, and therefore...
Those aren't your words, Mr. Jones. You say that the charges were dropped because of the negative impact her medication had on her. Those are your words, aren't they?
That is correct. She was not given the medication that day.
Mr. Jones, you didn't say anything about that in your witness statement. In your witness statement, you said the charges were dropped because of the negative impact that the medication had on her.
That's correct.
Okay. Now, whenever you investigated this case, this vandalism case, you met the defendant's father, right?
That's correct.
And you know the defendant's father pretty well, don't you?
You could say that.
You see him outside of work.
Sometimes, on occasion.
And you have mutual friends, don't you?
We have a couple mutual friends.
Right. And you said it yourself, that it would be completely inappropriate for you to be involved in this case.
Absolutely, which is why I objected to the sergeant and the chief of police that we take on this case.
But here you are today, testifying for the defense.
Sir, if a sergeant asks me to take this case, I have no choice but to take the case.
Mr. Jones?
Yes.
You think that it's inappropriate for you to be involved in this case, but regardless, you're testifying against the police force in favor of the defense. Isn't that right?
Yes, that's correct. She also had personal involvement.
Mr. Jones, that's a yes.
Yes.
You thought it was inappropriate for your involvement.
For both of us to be involved.
All right. Now let's talk a little bit about your testimony here today. You picked up Ms. Patel, isn't that right?
That's correct.
And then you drove to the defendant's house, isn't that right?
No, that's not correct. They drove to our house and picked and
regardless, you met up with the defendant and Mr. O'Leary, isn't that right?
Yes, that's correct.
And isn't it true that your car, it was unmarked?
Yes, but detectives typically don't drive marked cars. It still had the siren and the radio.
Exactly. So your car was unmarked?
Yes.
Now that we've established that your car was unmarked, you were also not wearing your full police uniform. Isn't that right?
We had the homicide jacket on, and we still had the gun holster and badge as well.
Is that a yes? This was not your full uniform?
No, but detectives typically don't wear full police uniform. We wear detective uniform.
Exactly. And you received permission from Quinn Patel's parents to interview her. Isn't that right?
Yes, that's correct.
And Detective O'Leary received permission from the defendant's father to interview her. Isn't that right?
Well, I was not there when Detective O'Leary picked up Dakota.
But in your witness statement, you say that she did.
May I finish the question? May I finish answering
the
question?
answer to my question is a yes, isn't it?
Well, he told me that her father granted him consent.
Okay. Now we've established that. You next told the defendants that 2 anonymous tips indicated that they knew something about the fire, right?
I'm sorry, can you repeat the question?
You told the defendant about the 2 anonymous tips, didn't you?
That's correct.
And you described the defendant's behavior as suspicious, didn't you?
Also very hesitant in high-pressure situations.
Is that a yes? You described her behavior as suspicious?
Yes, okay. Also hesitant.
So first, you took the defendant and Ms. Patel to the crime scene, the maintenance building, isn't that right?
That's correct. We took both of them there.
Isn't it true that this maintenance building is within easy walking distance of the defendant's home?
That's correct.
And isn't it true that you walked with the defendant around this maintenance building?
And through the charred remains of the building, that's correct.
We can agree that you did walk around this building that's within easy walking distance of the defendant's home?
That's correct.
Okay. Next, you moved on, didn't you?
We did. Detective O'Leary was using aggressive tactics, and
Detective
I told
O'Leary,
him that we should take a more
Mr.
understanding
Jones, let's talk about
approach.
what Detective O'Leary actually did.
I asked that my witness allowed to.
Need to let him finish his answer.
So, Mr. Jones, let's talk about what Detective O'Leary did. He told the defendant to tell the truth, isn't that right?
He did.
And after this, you moved on?
After I told him that we should move on and take an understanding approach.
Right. You moved on and drove past the victim, Sheldon Brown's house, isn't that right?
That's correct. where we saw grieving family members and his pregnant wife in the front yard.
And Detective O'Leary told the defendant it would be best to tell the truth. Isn't that right?
He did.
And next at 11 a.m., you drove the defendant and Miss Patel by Sheldon Brown's church and graveyard, right?
Again, that's correct, where we saw the fresh burial site.
And at this point, you claim that the defendant said something about needing medication, right?
She mentioned something about medication, that's correct.
Right. In your witness statement, you don't use the exact words that she said. You say that she needed something about medication, right?
Yes, that's correct.
And isn't it true that around 12 o'clock, you and Detective O'Leary bought the defendant lunch?
Well, he objected, and I insisted that we buy them.
Regardless of this, you bought them lunch, right?
For a quick minute, we grabbed them some lunch, that's correct.
And after this, you split up?
Yes, we did.
You took Quinn Patel, right?
Yes.
This was because you knew the defendant's father, right?
Well, I did not want to have any personal...
Right, you were trying to keep your personal interest out of this case.
Yes.
This has already been asked and answered. My witness has already established personal relationship.
This is cross-examination. It's appropriate. The objection is overruled.
Yes. So, Mr. Jones, you were trying to keep your personal relationship out of this case.
Yes, unlike Detective O'Leary, who kept it in.
After you questioned Quinn, you drove back to the high school, right?
That's correct.
And when you got to that high school, you and Detective O'Leary were about 30 to 40 feet apart, isn't that right?
That's correct.
And isn't it true that you couldn't see exactly what was going on in Detective O'Leary's car?
Well, you said it perfectly. I couldn't see exactly what was going on, but I got the gist of him shouting in her face and violently gesturing
Mr. Jones, we can agree that you could not see exactly what was going on.
No, I couldn't see exactly what was going on, but that's about 10 yards on a football field. That's not that far away.
Now that we've established that you couldn't see what was going on, you did hear the defendant scream, "I did it. I did it. I did it. I didn't mean to kill anyone. I did it." Okay? You heard that, didn't you?
Yes, after I got out of the car.
Now, isn't it true that after this and after her father arrived, you took the defendant to the police station?
That's correct.
And isn't it true that at that police station, the defendant met with her father and attorney in private?
Briefly, that's correct.
And after meeting in private with her attorney, the defendant said that she didn't know anything about the arson.
That's correct. She denied all involvement at all.
And isn't it true that you were assigned initially to write up the report on this case?
Yes, that's correct.
But after reviewing your report, the chief of police called it terrible.
Yes, and I don't know why. I very accurately represented the facts of the case.
Of course, this made you mad, didn't it?
Absolutely not. I'm a professional, and that's how I keep it.
Well, let's examine that. You were subject later to an internal investigation relating to your write-ups, to your reports.
Yes, the chief of police and I butted heads about how to write reports. He wanted me to
Mr. Jones, is that correct?
Yes.
You were subject to this internal investigation.
Because he wanted me to write the reports and misrepresent
Mr. Jones,
the facts
regardless,
of the case.
I ask for my witness to be able to answer the question.
Your Honor, I in turn object to non-responsive. I have a limited amount of time on cross-examination. If Ms. Bhatia wishes to address this, she may on redirect examination, but I have a limited amount of time. This question calls for a yes or no answer.
You're both right. You need to give him a chance to finish his answers. You need to be responsive to the question and not continue your answer beyond the point that it's responsive. Go ahead.
Yes, Your Honor. So, Mr. Jones, we can agree that you were subject to an internal investigation relating to your write-ups.
Yes, that's correct.
But before you went in front of the disciplinary panel, you took an early retirement.
Yes, because the chief of police offered me that retirement. Had he not, I would have obviously fought
Well, this was
or
before
gone through the disciplinary hearing.
Okay, we can clarify that this was before you were set to appear in front of this disciplinary hearing.
Yes, but had he not offered me this retirement, I would have gone through with the disciplinary hearing.
And you took that retirement?
Yes, it was the best option at the time. It was time to change careers.
Right, now you don't work in law enforcement anymore.
No, I do not.
Now you work for an insurance company.
As a fraud investigator, that's correct.
No further questions.
Any redirect?
Yes, Your Honor. On cross, you were asked about who talked to whom. Who did you specifically pick up?
I picked up Quinn Patel.
And I'd like to clarify, what were your perceptions of Sam's actions in this case?
The lying and the anger and the aggression, they were out of line.
This question was brought up on direct examination. I objected as it was beyond the scope of his expertise, the fact that his actions were out of line, and this testimony was stricken from the record.
What is your question again?
My question was, what were your perceptions of Sam's actions in this case?
Yes.
He testified that his actions were out of line. Thus, this is not rationally based on his perceptions. This requires outside knowledge, knowledge of protocol, expertise in protocol. And as was previously held on direct examination, this is not admissible, as it does not fall within the scope of Evidence Rule 701.
Objection is sustained.
Let's move on. So when you approached Detective O'Leary's car, what did you see?
I saw Detective O'Leary went off to the side to cool off after Dakota confessed to committing the crime.
And on cross, you were asked about your resignation. Why did you resign?
Well, I resigned because things just got complicated. The chief of police and I butted heads all the time about how to write reports, and he wanted me to write the reports to make the department look better and the arrestees look more unfavorable.
Objection, Your Honor, as to lack of personal knowledge. How Mr. Jones knows that the chief of police wanted him to do this is not known to the court. And furthermore, the only way he would know about this is from what the chief of police said to him, and therefore this would be hearsay, an out-of-court statement.
Your Honor, this is not testifying as to the truthfulness of the content, but rather just establishing the facts. On cross, he was asked about his resignation. He's basically clarifying why he resigned and on the reports that he was asked about.
Objection is sustained. Motion to strike is granted.
All right, no further questions, Your Honor.
Any recross? You may step down. Does the defense have any additional evidence to present?
No, Your Honor. The defense rests.
At this time, I will allow 2 minutes for each side to prepare your final arguments. If the timekeeper would please keep track of that time, thanks.
You are watching the 2013 Ohio High School Mock Trial Championship coordinated by the Ohio Center for Law-Related Education. We're coming to you from the State House in downtown Columbus. Right now, the students have a couple of minutes to prepare their closing arguments in the case State of Ohio versus Dakota Allen. Orange High School is arguing for the defense, Dakota Allen. Dakota's case is that the statements claiming responsibility for the school fire were coerced by the police and violate the Fifth and 14th Amendments of the United States Constitution. Dakota is filing a motion to suppress. Indian Hill High School is arguing for the prosecution, the state of Ohio, that Dakota Allen's motion to suppress should be denied because no custodial interrogation of Allen took place and Allen's confession was voluntary and not coerced. After the teams deliver their closing arguments, the judges will adjourn for a short while to deliberate, during which time I will have a chance to talk with some of the students participating today and get some of their perspectives. During that time, we will also have the opportunity to learn more about this historic building. When the judges are finished deliberating, they will come back in the room, give comments, and then announce the winning team. But first, we'll go back to the floor to hear the closing arguments.
How much time is remaining? Okay, thank you. Are both sides ready at this time to present
Yes,
your
Your Honor.
final arguments? Mr. Hall, you may proceed first.
May it please the court. We are here today because the defense filed a motion to suppress the defendant's 2 confessions, in which she admitted not once but twice to having committed arson and murder. Your Honors, the prosecution has met our burden by proving by a preponderance of the evidence that 1, no custodial interrogation occurred, and therefore no Miranda warnings were necessary, and 2, the defendant's 2 confessions were voluntary. In order to determine whether or not a custodial interrogation occurred, we must apply a 2-pronged test first set forth in the case of Thompson v. Keohane. The first prong of this test examines the objective circumstances surrounding the interview, and the second prong asks whether or not a reasonable person under these circumstances would feel free to leave. Your Honor, this is not an issue of whether or not the defendant felt free to leave. This is an issue of whether or not a reasonable person in her situation would feel free to leave. Now, the defense might tell you that the defendant felt uncomfortable, even scared. But in the case of Yarborough v. Alvarado, the Supreme Court held that the determination of custody involves no consideration of the suspect, in this case, the defendant's actual mindset. Your Honor, let's examine the objective circumstances that would influence how a reasonable person would perceive his or her freedom to leave. You heard today that the defendant is intelligent, calculated. You heard from both Detective Jones, the defendant, even Detective O'Leary, that the defendant has previous experience with the police. Your Honor, these circumstances, these objective circumstances indicate that a reasonable person would not feel intimidated or unfree to leave. Your Honor, you heard today from Detective Jones that the maintenance building, one of the sites where the defendant was taken, was within easy walking distance of the defendant's home. You heard him testify that they walked around this site. Your Honor, any reasonable person could have easily walked home if he or she wanted to leave. You also heard today from Dakota Allen herself that she had her cell phone with her throughout the entirety of this investigation. Your Honors, if any reasonable person wanted to leave, she could have taken that phone out of her pocket and called her father. You heard today that the defendant was alone in the back of the police car. There were no detectives in that police car. Your Honor, any reasonable person alone in that car with her phone could have called her father and asked to be taken home. And the defense cannot point to any testimony that indicates that either detective took any action to deprive the defendant of this freedom to leave, this ability to call her father. Now, the second issue today, proven by the prosecution, was that the defendant's two confessions were voluntary. In the case of Colorado v. Connolly, the Supreme Court held that examination of the confessant's state of mind can never conclude the due process inquiry. The court went on to hold that police action and coercion is a necessary predicate to the finding that any due process violation occurred. Your Honors, let's take a look at the specific actions taken by Detective O'Leary. You heard today that Detective O'Leary indicated that a cooperative attitude would be to the suspect's benefit. In the case of Ferry Michael C., the Supreme Court held that this indication does not render a subsequent confession to be involuntary. You heard that the detectives told the defendant to tell the truth. But in the case of State v. Wiles, the Supreme Court held that admonitions to tell the truth do not render a subsequent confession to be involuntary. You heard that Detective O'Leary even presented false, deceptive evidence, the video footage that she had not yet reviewed. But in the case of Lawson v. Bishko, the Supreme Court once again held that the presentation of such false or deceptive evidence does not render a subsequent confession to be involuntary. Your Honor, no action taken by Detective O'Leary renders the two confessions made by the defendant to be involuntary. Your Honors, the crux of the defense's argument rests on the testimony of the defendant. But today in court, we saw two different Dakota Allens. On direct examination, we saw the actress, the emotional Dakota. But on cross-examination, Dakota was calm, cool, collected in answering Ms. Park's questions. Your Honor, that's the real Dakota. You heard Dr. Highlander testify today that the defendant is no more susceptible to coercion than any average adolescent. In fact, she's less susceptible to coercion because she often manipulates authority figures and adults. You also heard today that the defendant is untruthful. When faced with disciplinary action, she misrepresents the situation in her favor. She lies about taking her medication. Therefore, we respectfully request that you rule in favor of the prosecution and deny this motion to suppress the evidence. Thank you.
Thank you. Ms. Badia?
May I proceed?
You may.
May it please the court. Your Honors, a man's rights are like the pillars of a sacred temple. They provide support for the temple and allow the man to live in peace, knowing that his liberties are secured. However, when those rights are taken away from one individual, the ideals of our nation begin to crumble like any structure that loses its pillars. The Fifth Amendment to the United States Constitution provides protections to persons involved in a criminal case from compelled self-incrimination. Furthermore, the 14th Amendment protects against coercion of involuntary statements. In this case, the government has violated both these pillars of democracy. The prosecution has argued that the interrogation pursued by Detective O'Leary did not require her to read Dakota her Miranda rights. Under Miranda v. Arizona, the Supreme Court made clear that defendants are protected from surrendering their rights guarded by the Fifth Amendment during a custodial interrogation. These interrogations entail compelling pressures that can induce a high percentage of people to confess to crimes they have never committed. Furthermore, the case of JDB versus North Carolina established a two-pronged test to determine whether or not a person is in custody. First, the court must examine all of the circumstances surrounding the case. And second, given those circumstances, the court must determine whether a reasonable person would have felt at liberty to leave. And according to that Supreme Court opinion, age is a factor that the court must consider in determining if a custodial interrogation took place. In this case, there are several undisputed facts that establish that no reasonable person, much less a reasonable 15-year-old child, would have felt at liberty to leave. The police kept this child in their custody for 7 hours in the back of a police car while driving the suspect around to psychologically disturbing locations. They refused to take her home when she requested it. They refused to get her the medication she needed. And Detective O'Leary in particular exerted her authority over her through constant yelling and intimidation tactics that eventually rose to physically shaking and striking the child. There is no question that Dakota felt she was in custody, and any other reasonable 15-year-old child would have felt the same way. Simply stated, this was a 7-hour custodial interrogation during which the police have admitted they never administered any Miranda warnings, when it would have only taken them less than a minute to administer those warnings. Furthermore, the 14th Amendment issues in this case involve a subjective test. The mental state of the subject, the duration of the interrogation, and the age are all factors in determining if a confession is voluntary. As a Supreme Court case of Haley v. Ohio established, a 15-year-old must be treated with special care during an interrogation. The fact that Dakota was grilled for almost a full day with no counsel to advise her firmly supports a ruling as in Haley that the confession made by Dakota was coerced. Add to those facts Dakota's mental condition, the fact that she was deprived of her needed medication through this day-long ordeal, that she was physically ill as witnessed by the police, and that the police used such morally detestable tactics as driving her to her mother's gravesite and showing her an empty, freshly dug grave, and not administering any Miranda warnings, all add up to the inescapable conclusion that the prosecution has failed to meet its burden of proving that the statements were not coerced. Finally, today, opposing counsel has relied on two cases, Fair v. Michael as one of them. This case has no applicability to the case at hand today, because in that case, Miranda warnings were given to the suspect, and the suspect knowingly and intelligently waived his rights. Furthermore, the opposing counsel also used Yarborough v. Alvarado. This case actually supports our side more. In fact, in that case, one of the clear facts pointing to a custodial interrogation is the fact that the suspect is never told that they are free to leave. In this case, Dakota was never told that she was free to leave. Finally, we would like to state that Dakota merely confessed to escape this horrible situation. Detective O'Leary admitted during her cross that she wanted to make Dakota fear for her freedom. When an authoritative figure creates a situation like this and emotionally attacks a minor by conjuring images of her dead mother, any minor would do anything, would break down to stop the psychological assault. Therefore, we respectfully ask the court to grant our motion to suppress. Thank you.
Thank you. Any rebuttal?
Yes, Your Honor. In her closing argument, Ms. Bhatia referenced the case of JDB v. North Carolina, where the Supreme Court did hold that age is a factor that must be considered. But the court in that case clarified that this does not mean that age will be a determinative or even a significant factor in every case. Your Honor, in the case of JDB v. North Carolina, the juvenile was only 13 years old, where in today's case, Dakota Allen is a 15-year-old, street-savvy, intelligent girl. Your Honor, Ms. Bhatia also referenced the case of Haley v. Ohio, stating that it indicated that this court must rule that Dakota Allen's confessions were involuntary, but in that case, Your Honors, The questioning started on the 20th and ended on the 23rd. It lasted for over an entire day. In this case, Dakota Allen was only questioned for 7 hours with a break. Now, the circumstances surrounding Dakota Allen's confessions, they must be taken into consideration. The first confession was made to Detective O'Leary, but the second confession, that was made to Dakota Allen's father. Your Honor, the defense cannot point to any coercive police activity when Dakota Allen confessed to her own father. Your Honor, Ms. Bhatia is right. The Fifth and 14th Amendments, they're pillars that support this country. But you heard Dr. Highlander testify today that Dakota Allen often manipulates authority figures. It's evident that Dakota treats this like a game. But Your Honor, a man has died, and Dakota Allen confessed not once but twice to starting the fire that killed that man. Your Honors, the Fifth and 14th Amendment are pillars, not get-out-of-jail-free cards. Therefore, we respectfully request that you rule in favor of the prosecution and deny this motion. Thank you.
I'd like to thank both sides for your excellent presentations on this motion. At this time, my colleagues will retire to begin their deliberations. You can be seated. Does either team have serious reason to believe that a material violation of any rule has occurred during this trial? I will remain on the bench for 3 minutes, during which time any protest or objection may be brought to my attention by a team attorney. The team attorneys may communicate with any student team members involved in this particular trial, but may not communicate in any way with legal advisors, teachers, or anyone outside their performing team members in this trial. As I indicated, you have 3 minutes. If at any time you determine that you don't have a post-trial objection to make, you can simply indicate that at any time during the 3-minute period. And you're keeping track of the time. Okay, thank you. Okay.
I'd like to confer with our timekeeper for a moment.
Sure.
Your Honor, there were slight time violations of the prosecution. Other than that, no other material objections.
We'd like to clarify that's not a material rules violation.
Time objections are supposed to be made throughout the course of the trial, not in post-trial objections.
Let me ask a preliminary question first. Are you making that as a post-trial objection?
No, Your Honor, I'm just making you aware of that.
Okay.
Okay.
Thanks.
Sounds good, Your Honor.
Once again, you're watching the Ohio Channel and the 2013 Ohio High School Mock Trial Championship. We're coming to you from the Ohio State House in downtown Columbus. We just heard closing arguments for the mock trial case, State of Ohio versus Dakota Allen. Today, acting on behalf of the prosecution was Indian Hill High School and the defense was Orange High School. Right now, the judges have retired to do their scoring, and while we're doing that, let's talk a little bit about the case. This year's case involves both the Fifth and the 14th Amendments to the United States Constitution, which both contain the Due Process Clause. The question in this case, State of Ohio versus Dakota Allen, is whether police interrogation of high school student Dakota Allen violated Dakota's constitutional right to due process. And once again, we have Lisa Eshelman of the Case Committee to help explain what we've been watching. Thanks for joining us again.
Oh, absolutely.
So as you watched the students argue the case just now, what impressed you the most?
What impresses me the most every year, including this year, is how polished these students are. There is no doubt in my mind that they have spent hundreds and hundreds of hours in order to get to this level of the competition. It's all just very exciting.
So the teams made some motions and objections, which were sustained and overruled. What was happening?
Well, during that period of time, there are a number of objections that could be made. Either a rule violation set forth by the OCLRE mock trial rules, or procedural types of rules. And it's up to the presiding judge, in this case Judge McBride, to evaluate the arguments of the students on both sides and issue that ruling.
Now, did those objections and the fact that they were overruled or sustained, did those affect how the students will be scored today?
It usually does not. What the judges are looking for is that the student understands what the application of the rule is to the facts, and then the response of the student on the other side. Like in any trial, lawyers are going to have objections, some of which are sustained and some of which are overruled. So that's to be expected in any trial.
And did the teams make the arguments that they expected, that you expected they would?
Oh, absolutely they did. And again, as we talked about earlier, the focus of this case is on whether or not it was a custodial interrogation and or whether or not Dakota felt that she could leave in order that Miranda rights would not be required in this case.
Well, it seems like the judges really have a difficult decision to make. Do you have any idea what they'll be deliberating about?
Well, they're certainly going to be deliberating about the application of the facts of this case, the thorough knowledge that the students have, both of how the application to the facts of the law as well as the constitutional issues. The judges also will be evaluating their trial performance as well.
Great. Thank you so much for joining us again to answer these questions. Is there anything you'd like to add?
No, it's just been a wonderful day, and I'm sure that the folks who have been involved with it also have had a great time.
Great. Well, thank you so much.
Thank you.
Thank you, Lisa. And now we can hear some from some of the students who participated today. So go ahead and have a seat. Hi, can you just tell me your name, your grade, and what team you're on?
My name is Shivangi Bhatia. I am in 11th grade, and I'm on Orange High School Team Shanghai.
Okay, wonderful. And can you tell me what your role was today?
I am the defense attorney, and I close, yes.
And how do you feel about your team's performance?
I thought we did very well. I'm very proud of my team for how far we've made it, and I think we did very well today, yeah.
Great, and can you comment on the other team and how the arguments went today?
Yes, I believe the other team did very well. It was a tough match, and I'm glad it happened. It was very nice.
Now that it's over, how do you feel?
I feel great. No matter what happens, I'm proud that my team made it this far and that we had the opportunity to be here today.
Did anything happen that was unexpected, or did everything seem to go as planned?
I think everything seemed to go as planned. We were confident coming in, so yeah, everything did seem to go as planned, yes.
What would you say is your team's main strength?
I think our team's main strength are closing and openings, and also our witnesses. Our witnesses are very good at portraying their character, yeah.
Great, and what is the most fun part of mock trial for you?
I think the most fun part, I really enjoy my cross and my closing, just like putting the emotion into it, and yeah, that's my most fun part. Yeah.
So you've been preparing for this for many, many months. Can you describe the process and especially your coaches and the role of the volunteers?
Yes, the process is very hard, and it's well worth it, and our coaches really do a great job of helping us. We have legal advisors, and they're always there every day giving us advice, and it takes a lot of effort, but it's well worth it once you come to this level especially.
And lastly, how does it feel to make it to the state championship?
It's amazing. My team was ecstatic when we found out yesterday. It's really a dream come true. I can't say anything else, yeah.
Well, thank you very much.
Thank you.
All right, and we have another student lined up. So what was your role today?
I'm the closing attorney for the prosecution.
Okay, and can you tell me your name, grade, and then what team you're on?
My name's Aaron Hall. I am a senior, and I'm on Indian Hill Red.
Okay, so I remember you guys were here last year. How does it feel to be back?
it's an honor, really. And to play against such a good team, Orange was amazing. Such a fun trial. It's just, it couldn't get better.
Can you tell me about the process leading up to making it here through the district and regional competitions?
Yeah, so this is our 9th trial this season, and you have to win each trial to make it to the end. It's been a journey. It's been pretty fun, I gotta say.
How is your team bonded through this process?
Well, this is our 4th year all being together for the most part. We had a couple new additions, but we've really grown to be quite close, and I love them. It's great.
Does your team have any unique ways that you practice for trial?
Well, I don't really know. I haven't seen many other ways. So I can't say if it's specific to our program, but we, of course, we work on the pieces and then scrimmage, practice, and it's a really fun experience all around.
Now, do you practice with the other teams from your school, or do you? Okay.
Yeah. There are 5 teams in total, and we do inter-team scrimmages and stuff, and each team is unique, and that's pretty much how it goes.
Do you find that the teams within your own school are competitive with each other?
Of course, yeah. This year, 2 of the teams, we had to play ourselves twice, and that resulted in, of course, inevitably 2 of our teams being knocked out by our own schools. So, I mean, it's very competitive in between the teams. At the same time, at the end of the day, we're all Indian Hill mock trial.
And you said that you're a senior and you've been here 4 years. Do you know what you want to do in the future?
Well, not exactly. I anticipate to study economics in college, but perhaps law school later. I don't know. Whatever. It depends.
Well, congratulations on making it here today, and I wish you the best of luck.
Thank you very much.
All right. And who's next? Hi, can you tell me your name, your grade, and the team that you're on?
Hi, my name is Evan Wall. My team is Orange Shanghai, and I'm a senior.
Okay, now I have to ask, how did you get your team name?
Well, we always pick a theme for our team since we have a lot of teams. This year we had 10 teams from Orange High School. So we thought Shanghai was a pretty unique and really cool city, so we picked it.
And the other teams, do they also have city names?
Yes.
And what were some of those?
Versailles, Madrid. Then some teams chose obscure cities such as Moose Factory, a city in Canada, and other fun ones.
That's really neat. So do your teams have a unique way of practicing for the competitions?
What we really like to do, we have a really great open environment, so we do a lot of self-criticism to each other after our trials, and that really helps make everyone better.
And now that the trial is over, how do you feel right now?
Relieved, but still excited. It was an amazing experience, especially as a senior, to get this far.
That's great. Did anything happen during the trial that you didn't expect?
No, most of what we've seen before, but Indian Hill, they were so well prepared. They were just great. They were amazing in every aspect.
What's the most fun part of mock trial for you?
I think the team environment. At the hotel this weekend and at past tournaments, we have a great group of people, not just our team and all the Orange teams, and we just love being with each other. That's the best part for me.
And how did you decide to participate in mock trial?
Well, I was, I'll say, recruited by a friend of mine a couple years ago. This is only my 2nd year. And both my parents are attorneys, so I've kind of got the attorney blood in me, so I wanted to try it out.
That's great. What would you tell other students who might be interested in participating in mock trial at their own schools?
Well, it's a great way to kind of explore career options of what you want to do. It's also great for public speaking and just being able to think on your feet. I mean, it's so applicable to many aspects of life, regardless of if you go into law or not.
That's great. Is there anything else you'd like to add?
I had an amazing experience. It was an honor to get here, and both teams, it was an amazing trial, and it's so much fun.
Well, congratulations and good luck.
Thank you.
Hi, can you tell me your name, your grade, and the team that you're on?
My name is Gloria Park. I'm a senior right now, and I'm on Indian Hill Red.
Okay, so you're a senior, and you've been here a few times before. How does it feel to complete this trial?
It was really relieving. I mean, I was definitely expecting a really good team, and that's what we got. So I was very on top. I tried to be very on top of things throughout the trial because they were doing a lot of great things, and I didn't want to miss any of that. So I'm really relieved, and I'm really happy that we got to play such a great team.
Did anything unexpected happen during the trial that surprised you?
Nothing unexpected, but the witnesses were really phenomenal. So crossing them was extremely difficult, and I just think that it was just really amazing to watch them.
What was your team's main strength today?
I really don't know what our main strength was. Like, I didn't really focus on my team because I watched them so many times. It was just sort of like distracted by everything that was going on. But I think The chemistry worked out really well for all of the members of the trial today.
Can you describe the process of preparing for this case and going through the district and regional competitions to make it here?
We don't really have a different process depending on the case. Most of us, we meet 3 times a day, or week, not a day, 3 times a week, and we just sort of follow the same process that we've been doing for the past few years because it's been working. So it's honestly just a combination of the team effort, our coaches, our legal advisors, and definitely our individual effort and how much we want to be successful.
Is there something new that you've learned about the law through this process?
I definitely learned how much more complicated it is. I did not really know about custodial interrogations until today, or not today, I mean like when we started this case, and it's just been a lot of learning for everyone, I believe.
That's great. And since you're a senior, do you know what you want to do in the future?
It sounds really random, but I'm stuck between either a double major in political science and international relations and then going to law school, or majoring in environmental science.
Okay, well that's great. I wish you the best of luck and congratulations. Hello.
Hi.
Can you tell me your name, your grade, and the team that you're on?
I'm Reagan Wilkins. I'm a senior, and I'm from Indian Hill.
Okay, and I know you played the detective today. Can you describe how you prepared for that role?
Sure. Well, actually, I just recently got the role, so it was a lot of just rereading the witness statement, and then my teammates would make up some crosses for me, and so it was a lot of trial and error.
Did you get any unexpected questions that surprised you?
I wasn't expecting the Miranda warnings, so that was a lot of fun because I actually got to use them.
Yeah, and you had that memorized.
Yeah,
so.
yeah.
What's the most fun part of mock trial for you?
Oh, I think the trials are really fun because, you know, you're meeting all these new kids and they're all so sweet, you know, but then you get them in court and, you know, it's really a fun competition to be in.
Yeah, it seems like it. So what did you learn about the legal process through participating this year?
It's a lot of work. You know, you don't really expect that, you know, the law would take so much time and effort because it goes so smoothly most of the time. So you really learn about the behind the scenes of it.
And how did you decide to participate this year?
Well, I've been doing it for 4 years, and so this year was like my last year to do it, and so I really just wanted to have as much fun as I could.
And I also learned earlier that you had a role on both sides, depending on how the coin toss went. Can you describe the nervousness of not knowing what you would have to do today?
Yeah, well, I actually played Dakota on the other side, so it's, you know, the complete opposite of what I played today. So I actually have to go change and like change my clothes, and so it's stressful because I'm scared I'm going to say something wrong.
Where do you see yourself in the future since you're a senior?
Oh wow, mock trials taught me how to do a lot of, you know, speaking in front of people, and so now I really enjoy that, and so maybe something to do with public speaking.
Okay, great. Well, I wish you the best of luck and congratulations. Hi. Can you tell me your name, your grade, and the team that you're on?
My name's Jordan Kahn. I'm a senior, and I'm on Indian Hill Red.
Okay, wonderful. And can you tell me what you think your team's main strength was today?
Probably say experience, and it was really nice also having a team as nice as Orange, because that made the experience really fun.
And I noticed that you were a bailiff, one of the timekeepers. Can you just explain for the audience what your role was during the trial?
Yes, well, I welcome the judges when they come in. You know, I tell everybody to stand up and sit down, and then I also just keep time and make sure that nobody goes over time.
Okay, great. How did your team prepare for the trial this year?
Just practice, a lot of practice throughout the week and various scrimmages with our other Indian Hill teams.
And so I understand your school had multiple teams. Did you feel competition between the teams as you guys prepared through the district and regional competitions?
I'd say once we made it 2 districts and regionals, we did feel a little competition, but we're really just one big family, so not that much.
Okay. What would you tell other students who might be considering participating in mock trial?
I tell them to I'd try it out. It's a great experience. You gain a lot of great friends and really invaluable skills.
Okay, and lastly, how does it feel to be here in the State House and arguing before these judges?
Oh, it's amazing. It's really an experience that I'll never forget.
All right, well, thank you very much, and good luck today. Hi. Can you tell me your name, your grade, and the team that you're on?
Yes, my name is Catherine Fay. I'm a senior from Indian Hill High School.
Okay, and you had more of an acting role. Can you explain your role today?
Yeah, I played Dr. Casey Highlander, who is the school guidance counselor, and she counsels Dakota Allen.
Did you get any unexpected questions that surprised you?
Yeah, I guess every cross from a different team is a little bit different, so you have to be prepared.
What's the most fun part of mock trial?
The best part about mock trial is the camaraderie. You know, we get really close as a team, and we're all really good friends. So
That's great. Can you describe the roles that your coaches and the volunteer attorneys had?
Well, basically, our legal advisors are the best ever. You know, I don't think we definitely couldn't be here without them, and you know, they're definitely a huge help.
What is one thing that you learned about the law or the legal profession this year?
I think every year we do mock trial, we get, you know, a new case, and we find a way to make that case relevant to our lives. So if just something's happening at school and, you know, someone's asking someone else questions, you know, we like to throw in some inside jokes about mock trial, like, oh, you're totally coercing that person, or things like that.
That's great. It's good to see that you can apply it to your life. So you're a senior. Do you have any plans for the future?
Well, hopefully I'll go to college, but I don't know where yet. Still waiting to find out.
Do you know what you'd like to study?
Probably engineering, which I guess is a little bit different from mock trial, but I don't know.
Yeah, I'm sure the skills that you learned will help you there too. But good luck today and congratulations.
Thank you so much.
Hi. Can you tell me your name, your grade, and the team that you're on?
I'm Lauren Schwab, and I'm on Red Team from Indian Hill.
What was your role in the trial today?
I was just observing. I'm the third attorney, so I play on defense when defense is called, but prosecution was called, so I didn't play this year.
So how do you feel about the coin flip? Are you happy with the outcome, or do you wish you would have had a role?
Well, I always do wish I had a role. The same thing happened last year, so I didn't play that year either, but I'm happy as long as we played. So.
That's great. Now, you guys were here last year and you won. So did you go to the national championship, and how did that work? Can you tell us about that?
Yeah, each state gets a different case, so we had to learn a different case. We went to New Mexico. It was a lot of fun. It was a great experience.
That's wonderful. So did your whole team go, or just the one side?
I think our whole team went. So.
Okay, wonderful. What's one thing that you learned about the law this year?
Well, we learned a lot of different cases, basically how intricate the law can be, and it's just a really great experience to learn different, you know, like tidbits from each different case, and like kind of find loopholes and see different things, and I think that's interesting.
What would you tell a student who might be interested in participating in mock trial?
It's a lot of work, but it's a lot of fun, and it's definitely worth it when you have like such excellent competition like we had today. It was just a great match.
That's wonderful. Thank you so much. Congratulations and good luck. Hi.
Hi.
Can you tell me your name, your grade, and the team that you're on?
My name's Hannah Levine, and I'm in 12th grade, and I was on Team Shanghai for Orange.
And you played the part of Dakota Allen, is that right?
Yes, I did.
Okay, so now that the trial's over, can you tell us, Dakota, did you commit the crimes?
Absolutely not. I had nothing to do with it.
Okay, still in roll. That's very good. Did anything happen during the trial that you weren't expecting?
I was expecting most of the questions that she asked. She asked them in a different order than I'm used to, which threw me off a little bit, but I'm happy with the way I answered them.
What do you think your team's main strength was?
I think our main strength was that we were able to keep composure, we held our own, and I think that as a witness, we were really able to get our acting down and answer questions well.
Yeah, you had a very dramatic role. You had lots of emotions going on. How do you keep it real?
I had so much fun playing this role. I act a lot in high school, and I've never really played a role like that, and you have to keep the mindset of what you're supposed to be thinking in this case to help your side win.
So I'm sure you learned a lot about acting, but did you learn anything about the law that you'd like to share with us?
I learned a little bit about the law and what goes into determining if someone's in custody or not, how age plays a role, and how your feelings and emotional state plays a role in it.
That's great. And does your team have any unique ways of practicing?
We practice a lot, but nothing really unique. We just work really hard.
And can you tell us about your coaches and the volunteer attorneys that helped?
They are absolutely amazing. They helped us through everything. We would not be here if it weren't for them.
And so you're a senior. Do you know what you want to do next year?
Next year I'm going to the University of Michigan, and I want to start studying medicine.
Wonderful. Congratulations and good luck.
Thank you.
Hello. Can you tell me your name and your role in the trial today?
I'm Dan Wenstrup. I'm a legal advisor for Indian Hill Red.
Wonderful. So as you guided your team through this process, what did you think was the most important thing for the students to learn?
Oh, you know, there were probably several, but we started out with the rules of evidence. We really worked hard on that. From there, we went to learning the case law, and then finally how to get the most out of the witness statements to ask penetrating questions.
That's great. And where do you work, and do you practice in this area, or was this something new for you?
Well, I practice in Cincinnati and outlying counties. I'm with the firm of Heiss and Wenstrup, and I'm heavily involved in the field of civil litigation.
Great. So how did you drill your team? How did you get them ready to come to the championship?
Well, they certainly had to stand up and recite all the rules for us, and then it was a matter of cross-examination. We really think that cross-examination is probably more important than the direct, and that's where the real battle is, and they seem to love it.
And how do you feel about your team's performance today?
Oh, I'm just so proud.
That's great. Is there anything else you'd like to add?
All I can say is that these kids are just wonderful and talented on both sides. I guess I would also like to thank the Cincinnati Bar Association and the Claremont County Bar Association, well, I especially would like to suggest that both of those are just so helpful, and I appreciate all their work.
Great, thank you very much. All right, and our last one. Can you tell me your name, your grade, and the team that you're on?
Karan Bafna, I'm in 12th grade, and I'm on Team Shanghai from Orange High School.
What was your role in the case today?
I was Alex Jones, the former detective who defended Dakota Allen.
Did you receive any surprising questions?
Yeah, I received a bunch of those. Aaron Hall is one heck of a lawyer, and he definitely hit me with a few surprising questions.
That's great. What was your team's main strength today?
I would have to say Evan Wall, our attorney, he really did well on the cross, and I thought he performed the best.
What's the most fun thing for you about mock trial?
Just hanging out with everyone, really getting to know everyone, the team spirit that we had this year. This was actually my first year doing mock trial, and it's been quite the experience.
So, being in your first year, what advice would you give to students who might be considering joining mock trial at their schools?
Work hard. I mean, it pays off. I mean, we honestly 2 months ago I would have never thought that we'd be in the state championship, and really we worked hard, and it really has paid off.
How many times a week did you meet, and what was the process for preparing?
We met about once a week typically, but then as the competitions came closer, we would meet 2 or 3 times a week. The day before, we would spend from after school to like 9, 10 o'clock in the evening working.
That's wonderful. Is there anything else you'd like to add?
No, not really. Just have fun doing mock trial and do well next year.
All right, well, thank you very much, and congratulations on making it here. Let's learn about the 7 judges for this year's competition. Former Justice Robert R. Cupp serves as Chief Counsel to the Ohio Auditor of State. He was elected to the Supreme Court of Ohio in November 2006. Prior to his election, former Justice Cupp served on the Ohio Court of Appeals, 3rd Appellate District, which comprises 17 counties in northwest and west central Ohio. Before becoming a judge, Justice Cupp served 16 years as a member of the Ohio Senate, beginning in 1985 and ending in 2000 with the advent of Ohio's legislative term limits. Before his election to the General Assembly, Justice Cupp served as a Lima City prosecutor and assistant director of law, and twice was elected Allen County Commissioner. Gary Daniels is originally from Youngstown, Ohio. He is the associate director of the ACLU of Ohio and heads the ACLU of Ohio Regional Office in Columbus, where he's lived since February of 2008. Mr. Daniels has worked for the ACLU for over 10 years, from 1995 to 2000, and in 2003 to the present. Before becoming Associate Director, he worked for the ACLU of Ohio in the position of Litigation Coordinator. Mr. Daniels currently serves on the boards of the Ohio Center for Law-Related Education and Community Shares of Mid-Ohio, where he's also on that organization's governing committee. Judge Jerry McBride received his Bachelor of Arts in Political Science and his Master's of Public Administration from the University of Cincinnati. Judge McBride currently serves on the Claremont County Common Pleas Court. He has also previously served as judge for the municipal court and as county commissioner for Claremont County. He is a member of the Ohio High School Mock Trial Competition Committee and is today's presiding judge. Commissioner Lynn Slaby was appointed to the Public Utilities Commission of Ohio in 2012. Prior to his appointment, he served in the Ohio House of Representatives. He represented the 41st District, which includes parts of Summit County. Commissioner Slaby received his Juris Doctorate degree and Bachelor of Science degree in Business Administration from the University of Akron. He recently retired from the 9th District Court of Appeals. Before his appointment and election there, he served 14 years as Summit County prosecuting attorney. Shirley A. Cool-Cochran is an attorney and mediator in Columbus, where she started as an assistant attorney general in 1979 after graduating from the University of Akron School of Law. She has also been a contract employee of the Supreme Court of Ohio as its circuit rider, a mediator and magistrate for the Claremont County Common Pleas Court, a hearing officer for various state agencies, including the Ohio State Racing Commission, and a solo private practitioner of law and mediation. She started with the Ohio Mock Trial Program as a local judge in the second year of competition, and is currently a member of the Ohio High School Mock Trial Competition Committee. Thomas D. Lammers serves as president of the Ohio State Bar Foundation and practices law with the firm of Purdy, Lammers, and Schiavone in Salina, Ohio. Mr. Lammers has served as president of the Mercer County Bar Association, a member of the Council of Delegates and Board of Governors of the Ohio State Bar Association, and is past chairman of the Ohio State Bar Association's Unauthorized Practice of Law Committee. He was admitted to the practice of law in 1977 after completing his undergraduate studies at Ohio University in 1974 and receiving his Juris Doctorate from the Ohio State University College of Law in 1977. Judge Patrick Fisher serves as president of the Ohio State Bar Association and as judge for the 1st District Court of Appeals. Judge Fisher was elected to serve as president of the Cincinnati Bar Association for 2006 and 2007. He has served on the Ohio State Bar Association's Board of Governors, chaired its Budget and Headquarters Committee, and served on numerous other Ohio State Bar Association committees and task forces. Judge Fisher chaired the Cincinnati Bar Association's Ethics and Professional Responsibility Committee, as well as its Professionalism Committee. He also served 2 terms on the Ohio Supreme Court's Commission on Professionalism, including serving as its vice chair. Those are the judges for the 2013 Mock Trial Championship. The judges are deliberating right now, but they should be back soon, so let's go down to the main floor.
I'll reserve my general comments until after each of the scoring judges has had an opportunity to speak. And we'll start in the same way that we introduced ourselves. Justice Cupp, you can go first.
All right. Thank you, Judge. Well, first of all, in addition to the hard work of the students, I want to thank the advisors and the parents for your encouragement and your support of these young people to give them this tremendous opportunity to learn about our legal system and about themselves and to improve their schools. It's just, it's just really a wonderful thing. I thought the teams were pretty evenly matched and was very impressed with the civility and professionalism that was demonstrated If I would have just one comment to make for a suggestion is just to remember not to talk too fast so that everything can be clearly heard. But I thought it was a wonderful presentation that all of you did.
I echo that. I think the reason I was invited is because I'm the president of the Ohio State Bar Foundation, which grants the funds to help support OCLRE. And from my observation today, the funds are being very well spent. You're all very intelligent, very smart kids, but there's a lot of smart people out there. But for those who put the hard work and discipline with that intelligence, you demonstrated that. I couldn't be any more thrilled to be here, and I congratulate you on both teams doing an excellent job.
I'll echo those comments made by my colleagues here. This is my 5th year in a row of doing the final round. Sometimes I wonder if it'll be my final year because you guys make this very, very difficult. My great fear was that the scores would be tied when I added them all up. That wasn't the case, so for this year. This is, I think, maybe the most, and maybe I say this every year, but I think this might have been the closest I've seen two teams. It was certainly lawyers on both sides. I think it's the 4 lawyers were the closest together in performance and capability, both with the case itself and how you conducted yourself that I had seen in these 5 years. The witnesses, too, were all great. If I could for all 4 witnesses, nobody did bad. That's for sure. I would say for the witnesses, though, we're judging here on the law and courtroom decorum and how well you understand everything and how well you make your case. I would say for the witnesses, there's just a slight amount of be careful how much you're trying to help your team, because sometimes it just starts to veer off into non-believability with how much you're trying to help. But that said, all 4 of you were excellent with what you did. You have to understand that when we're sitting here trying to give constructive criticism, we are really splitting hairs at this point, because you were all just excellent. But I wish I could offer something incredibly constructive to any of you or all of you, but you all just did such a great job this year that it was hard for me to pick out any particular flaws with anything that you were doing. So that said, I will punt to another colleague here.
Thanks, Gary. How many of the high school students here think they might go to law school? Please raise your hand. I want to say on behalf of the 25,000 members of the Ohio State Bar Association, I hope you do, because you will increase the quality of the bar. No, you are excellent young people. You've shown great demeanor. The bar is a great place to be. The law is a great profession, and I hope that each of you consider going to law school. You'd be a great addition to our profession. And I'm saying that as president of the bar. But also, I also want to say, as a judge, an appellate judge, I'd be honored to have any one of you who's appeared here today in front of me in court. I'm honored to be here with you. Thank you.
I echo those comments, and my comments are usually addressed to the witnesses, because in addition to being a lawyer and a mediator, I do community theater here in town. We have a group called the Lawyers Performance Ensemble, and we do law-related plays. So I'm a little bit torn between being the lawyer and being the witness, but it's very difficult for children, I say children, young men and young women of your age, to play adults who've had 20-some years of experience. And it just fascinates me every year when I see you guys not only step up to the plate, but hit home runs. And I will say that in the past, I've judged the final round, not recently, but and I think you guys are probably the most evenly matched set of teams that I have seen in the 29 years I've been judging this competition. So kudos to you, your advisors, and your families for their support in the hard work that you did to get here. Thank you.
Well, as they say in the All-American Soapbox Derby, congratulations to the champions. Each and every one of you are champions. When you dedicate your lives, which you obviously have for the last several months, along with your parents dedicating and your advisors dedicating their lives to this venture, you are all champions. Obviously, I echo everybody's sentiments here. You've done an outstanding job. I would second the encouragement to become attorneys because you would be good. You were good here. I also want to thank the bailiffs who sometimes get overlooked. You did an outstanding job. And I also have judged a number of final rounds as well as the initial rounds from the region to the state. And it gets tougher every year for us judges because you're better and better. I don't know how you can get better, but somehow you seem to. But congratulations again to each of you champions that are here today.
Yeah, I echo all the comments that have been made. I'm not going to repeat them, but both teams were outstanding, and it was a very close competition. And sometimes it gets lost in this, but this is an educational program. It's also a competition. But all of you obviously are champions, as was indicated, in terms of what you have gotten out of this program. And it's really very gratifying for me to see how well each and every one of you did. Parents and friends, you have reason to be proud, obviously, of the performance of the students in this competition. I mean, they just did a tremendous job, and obviously your support was essential in them doing that. Preparation sometimes gets overlooked, and I got involved in this, it was about 10 years after the mock trial started, and somebody came in my office whose team had won the state championship in mock trial, actually had won it 2 times. And he started talking about mock trial, and he said, you really ought to get involved in this some way because it's just a wonderful program. And he talked on and on. And so a year or 2 after that, I asked him, tell me, because I've been judging for a while now, but tell me, how much time do students put in getting ready for mock trial? And he gave me numbers, probably not nearly what you've put in, but he gave me numbers that I was really awed with in terms of time they spent with him as the legal advisor, and then time they spent on their own with the teacher. And the preparation really, I mean, obviously you're all very bright, you have great futures ahead of you, but the preparation, how much time you put into this really shows too, because everything was just so polished. No real mistakes. I mean, very, very, very good. And you are to be congratulated, both teams, for how good your performances were today.
My name is Todd Birch. I'm mock trial coordinator with the Ohio Center for Law-Related Education. We're now ready to begin the awards presentation. Before we do, on behalf of the center, I'd like to congratulate everyone here on a great season. Out of more than 365 teams, the largest mock trial competition since 2006, you're the only 2 left, and that's a great accomplishment from both teams. I'd also like to thank all of OSCELRY's sponsors, the Supreme Court of Ohio, the Attorney General of Ohio, the Ohio State Bar Association, and the ACLU of Ohio, as well as the support of the Ohio State Bar Foundation for helping to make this competition possible. I'd also like to thank all of our volunteers, our legal advisors, our final round judges here today, and all the judges, coordinators, and other volunteers who put in their time throughout this season to help make this competition possible. Without these countless volunteers, we wouldn't be able to do what we do here today. What we'll do first is I'll invite an advisor up from each team to introduce each member of his team. We each receive a gavel here from Judge McBride. We'll then introduce the individual award winners, and finally, we'll introduce the winner of this 30th annual mock trial state championship. So if I could just ask Judge McBride to please step down. And if I could invite, first from the prosecution, if I could ask Steve Rieger of Indian Hill to come up and please announce his team. We have a hand mic over there, Steve.
Don't think I need it.
All right, to introduce the Indian Hill prosecution, my magnificent seven. Senior Aaron Hall, attorney. Senior Gloria Park, attorney. Attorney on the other side, Senior Lauren Schwab. Our Sam O'Leary and our Dakota Allen, Senior Reagan Wilkins. Our Casey Highlander, Senior Catherine Fay. Our Dr. Martinez on the other side, Senior Julia Horst. The best bailiff in the business, Senior Jordan Kahn. And I'll quickly call the coaches up, our coaching staff, Dan Wenstrup. Sean Evans. Michelle Rothside. And I said of this group last year that they were all juniors and they'd be back, and I was right. And they're all seniors. They're gone. The Indian Hill prosecution.
Thank you. Thank you. If I could now invite Dave Shorters from Orange High School to do the same and introduce his team.
Thank you, Todd. All right, so we have Orange Team Shanghai, and they're one of three teams down here today. And I do want to say something about all of our members here today. It was really neat to see how many of them all worked together to help Shanghai, even after they had lost. So that's to be commended for all team members here. For Team Shanghai, Junior Shivangi Bhatia. Senior Attorney Evan Wall. Senior Kern Bafna, Alex Jones. Senior Hannah Levine, Dakota Allen. And from our prosecution, Attorney Senior Camille Rexon. Senior Attorney Cameron Dempsey. Sam O'Leary, Matt Fisher, Senior. And the amazing timekeeper, but also on the other side, Casey Highlander, Dr. Casey Highlander, Jacob Kirsch, Senior. I'd also like to call up all of the amazing volunteers and teachers that have helped us, legal advisors Chuck Jarrett. Pippa Carter. Alicia Wilson-Turner. And my assistant, Vikas Tarakia. And another assistant who was a former Orange attorney, went to the States, our first group that went to States, Alex Stankovic. This is the Orange Mock Trial Team Shanghai.
It's now time to announce our individual award winners. In each trial, one witness and one attorney is chosen who received the most total points from all of our scoring judges on the panel. And first, I will announce today's Outstanding Witness Award winner, And from Orange High School, Miss Hannah Levine. Congratulations. And our Outstanding Attorney Award winner from Indian Hill High School, Mr. Aaron Hall. Congratulations. We're now to the moment you've all been waiting for. First, I will announce the winner of this year's state championship who can come up, receive your trophy, and be recognized. We'll then be announcing the state runner-up. We'd also ask them to come up and be recognized. Also a great season, obviously, for both teams. And without further ado, our 30th annual O'Sullivan Mock Trial State Champion is Indian Hill High School. Go up and get your trophy. Now I'd like to recognize our state runner-up who had a great season in their own right, Orange High School. Thank you all. That concludes 30 seasons of O'Sullivan Mock Trial, and here's hoping for 30 more as good as this. Thank you.
You've been watching the Ohio Channel's coverage of the Ohio High School Mock Trial Championship Competition. Once again, congratulations to the winning team, Indian Hill High School from Cincinnati, Ohio. They will head to the National Championships in Indianapolis, Indiana. To purchase copies of this program or to view it for free online, visit us on the web at ohiochannel.org, where you can also view live and past video coverage of your Ohio government, including the Supreme Court of Ohio. For all of us here at the Ohio Channel, I'm Caitlin Schultz. Thank you for watching, and we'll see you again next year.